remember, the road to hell is paved with good
Well, it's
intentions.
exactly the same. Again, you know, I'm watching daytime television.
Yeah.
And all of the advertising, you know, to sit there, there's back braces and knee braces.
Oh, yeah.
These little, you know, carts to get you around. Not that those things are seated,
What?
but it's kind of like, oh,
Well,
optimism.
you know, what it really comes down to, and again, it always comes back in my estimation. It never bothers me when somebody wants me to give them more than I've got. It never bothers me when somebody asks for that. If they're going to take it from me, that's a different story. But if they ask for it, as long as they can accept the fact that I can say no, and that's the end of it. I agree. I agree. There's a reasonable part of my responsibility as a human being to my fellow man. Well, right. Right. So there are people that my best friend before he died had a brain tumor. It was it created physically, it didn't make him look weird at all. There was no obvious disability. He could walk fine, he could talk fine, his arms and legs moved, and everything else, eyes tracked properly. But he got these just absolutely staggering headaches.
That's a true disability.
Exactly. But he had to go to attorney to get disability through Social Security. Exactly. So what they don't tell you when they give you this whole thing about, you know, come to us and we'll get your Social Security, what they don't tell you until you get in their office, of course, is that, oh, by the way, we only win about 10% of these cases. So that's what.
If that's the truth, I actually feel better about it.
Yeah. Well, and it's because so many people are applying for it who really don't have a.
I'm suspecting that the very top in
Yeah.
I haven't looked at statistics.
No. They're making money.
Like I said, I know a guy in the neighborhood who, went through and he did get business disability, he did have disability.
Yeah.
But there was absolutely some he wasn't going to be able to get a bunch of office in the warehouse with disability.
Good. I agree with you. I agree with you. Because you see, the problem is, like when I was 19, I injured my back at work, and I was working for a family friend. When we figured out what was wrong with it, I went to the doc. The doc, our insurance, my dad's personal insurance, paid for everything. There was no problem with the process. It all got taken care of. But probably if we had filed workman's comp, I would have had my entire college education paid for, because it disabled the Army. So it was pretty significant disability. But having said all that, we never thought about taking George, doing a thing when George would get hurt by it. George wasn't. I did something at work and it caused me a problem. Everybody takes their own responsibility, and then when you're in someplace like, you work like I work for a trucking firm, and OSHA required me to put handrails on the stairs going up from the ground up to the dock. But the handrails, the place you can step up, they came down at the door openings, so that you stepped off onto the first step. You swung out to that first step and down those two steps. Yeah. Well, if you put the handrail in, the first ones that went in will be wonderful, we got just destroyed by the trucks in the back end. Because you can't see a half-inch pipe, see what I'm saying? So it actually created danger circumstances. Now you have crushed pipe sticking up weird, doing weird stuff. So there's sense and there's nonsense. We also had a gate fall over on a guy, killed him. The rolling hit him. That was 100% our fault. No offense whatsoever. And we should have been, beaten to death on it. That's not what happened either. So, you get both sides of the equation, but the truth of the matter is, right, right. My mom was walking on the sidewalk here at Costa Mesa, fell down and broke her wrist, and it was from a raised slab, two slabs different. Yeah. And so she broke her wrist, and she filed a claim to the city saying, hey, I stepped up, we talked, you've been calling this way before. I tripped on it, fell, broke my wrist, paid my doctor bill, paid the doctor bill. Made her go get it from me. She got the attorney. She came back, they paid her doctor bills, plus an extra couple grand. Oh, look at you.
Look how honest.
Oh, God, love you.
There you go.
Very nice.
So,
Thank you.
you know how to turn on. Okay.
We're good. I know how to do it. Thank you
You're
so
welcome.
much. Appreciate it. Anyway, so they wanted what they wanted to pay, the total amount they paid. It turned out that they paid the same amount they were paying on doctor bills 4 times. They paid the doctor bill itself and insurance.
That's unfortunate that some of these folks will say no until they get a lawyer.
And I talked to risk manager here in the city, and they said we get this all done. We don't pay any of it until somebody files a claim, files a suit. I said, well, that's stupid, because if they're going to file a suit, let's do the small claims court. You're going to have an attorney.
Almost the same thing. She from the school. And I raised him to her. I think I remember her in the past. She could. Okay.
Oh, yeah, because this is
So she actually went to the small business first. That's when I told her that the children were short of money in the city.
wow.
Had to pay for something.
That's a fair.
And the guy, the homeowner got to think I one day and said, you know, what for your house? And so I realized, based on the information, got it, called the city of the
I hear you. I hear you. Yeah. 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 Because we have my AT&T and my
No, it's a different company.
no, I know. What I'm saying is
It doesn't have functionality.
people think oh, I know, well, I understand that. I'm sorry, I
You can
understand.
report all of the same thing.
Who is it? This one?
Costa Mesa, you could go look at what's going on in your area, and they don't even know how, oh, that already been open. Oh, yeah, you can't look.
Yeah, but you know, I'm there right now. I was joking. People playing that against me this week. Last year, he got approved. He imposed.
Good evening. Welcome to the Costa Mesa Planning Commission meeting for Monday, January 13th, 2020. Unbelievable. Call the meeting to order and ask Commissioner Russell to lead us in the Pledge of Allegiance. Thank you, Commissioner Russell. Julie, roll call, please.
Chair Jericho.
Here.
Vice Chair Harlan.
Here.
Commissioner Colbert.
Present.
Commissioner Perkins.
Present.
Commissioner Russell. Here. Commissioner Torje.
Here.
And Commissioner Zick.
Here.
Thank you, Julie. We have no announcements or presentations on the agenda tonight, and that brings us to public comment. To ensure fair and equal treatment of all who appear before the Planning Commission and to expedite city business, speakers may be limited to 3 minutes during public comments to speak on any item within the Planning Commission's jurisdiction, which is not listed on tonight's agenda. This time may be extended for good cause by the chair or by a majority vote of the Planning Commission. Is there anyone who wishes to speak during public comment tonight? Yes, ma'am.
So Monday is Martin Luther King's birthday, and so He said a lot of great things, but this is one simple enough for me to remember. The time is always right to do what is right. That is so simple. Well, tonight you have an opportunity to do the right thing. Instead of just listening to the staff, no offense, but I don't think they have the residents' rights and our well-being in their forethoughts at most of the time. I think it's all about money and power and who shuffles who around here. And I think that way about some of the planning commissioners, but I'll keep that to myself. So tonight you have a sober living thing, and we'll get to that later. But remember, all of these issues that have come before you where they've asked for variances because they are underparked, I am asking you not to believe any applicant that comes before you, either sober living operators, no offense, some restaurateurs, all kinds of things. When they say they only need a certain number of parking spaces, that isn't always true. It's frequently misrepresented, and I hope you will keep that in mind tonight. And also with the cell phone towers, there's new technology coming out almost daily. As long as you can stall this or do whatever you can to keep so we can get the latest and the greatest and not just relying on technology information from 1996. That's borderline insanity in my opinion. Thank you.
Thank you. Anyone else wish to speak during public comment? Again, items not on tonight's agenda. Okay. I will close public comment, and that will take us to Planning Commissioner comments and suggestions, and we'll begin with Commissioner Tourget.
Thank you. I'm glad to be here tonight. I have a little bit of a cold, and so if I sound a little scraggly, that's why. I'm glad to be here in the new year. I think Commissioner Perkins will have a lot more to say on this, but the Costa Mesa Alliance for Better Streets has been doing a lot of great work in the city, and I would just encourage anyone doing work in bicycle and pedestrian planning to consider folks who are walking and biking at nighttime, and often we call them invisible riders. And so my thoughts on that are just keep going, doing the good work of doing bicycle and pedestrian advocacy, but also considering folks who might not be able to make it out during the daytime or to the normal rides that are scheduled. So those are my comments for today, and thank you for excusing my voice tonight.
Thank you. I hope you feel better soon. Commissioner Perkins.
Thank you. Just wanted to report back. I had talked before about the holiday ride for delivering cookies to firefighters and police. That was a great ride. We had more than 30 riders at the start. The police department even blocked off some of the streets for us near City Hall, which was fantastic for the children. They loved that, with lights and sirens going. We delivered cookies to every fire station and police station in the city. The next Costa Mesa Community Ride is going to be coming up on January 26th at 2 p.m., so keep an eye out for that. And then Commissioner Tourget mentioned the Costa Mesa Alliance for Better Streets. We are having a meeting on Monday night, January 20th, to talk about what we want to do in 2020 to make streets better. So that was the meeting she was referring to. So thank you very much.
Thank you. Commissioner Zick.
No comment.
Okay, Commissioner Russell.
No comment.
Okay, Commissioner Colbert.
Yeah, just Happy New Year, everyone. It's good to be back. Really excited about the forthcoming year. I think this next month we'll probably make a year of service on the commission, so I'm really excited I'm looking forward to another year of service with my colleagues to my left and right. And also just wanted to say Happy Founders Day to the women of Delta Sigma Theta Sorority Incorporated. That's it.
Okay, thank you. Vice Chair Harlan. Nothing. Okay, just real quick, Happy New Year. And also, I wanted to acknowledge staff and the work of the City Council at their last meeting with respect to passing a formal resolution objecting to the kind of ad hoc, out of the blue methodology that the Southern California Association of Government Regional Council used to come up with the sixth cycle RENA allocation, which is Regional Housing Needs Assessment for Costa Mesa and for all the cities in the SCAG region. that number, the methodology used means that Costa Mesa would need to plan for more than 11,000, almost 12,000 new homes in Costa Mesa over the next 8 years. In my mind, impossible task. So hopefully the methodology will be scuttled by SCAG, and they'll go back to the methodology that they were about to adopt, which would still place Costa Mesa having to plan for more than 4,000 units. Regardless of what happens, Costa Mesa, the future of Costa Mesa is going to look, in my mind, significantly different than it does today. I think to some respect, the Planning Commission and the City Council has some responsibility to plan for future generations and not just preserve the city for current generations. And so this whole RENA process, housing element update process that the city is going to be going through over the next 18 months is going to need to involve all of us, planning commissioners, city council, members of the public, with, I hope, a recognition that over the next 8 years, it behooves us to make housing plans that take into account the needs of my children and my grandchildren, your children and your grandchildren, so that we still have a vibrant economy going forward and a place where all workers can live in Orange County, and not just folks who are fortunate to have purchased here in 1950 or 60. And we just need to make sure that we have housing that spans a range of economic conditions and household income. So that's just kind of my laying the groundwork for what I hope to be an interesting, creative, and highly productive scope of work among all of us in the City Council and the community going forward on the housing element. So having said that, we have no consent calendar tonight, and that will take us to public hearing item 1. Julie, please.
Public hearing item number 1, a resolution recommending that the City Council give first reading to an ordinance, Code Amendment CO-19-04, amending Title 19 and Title 13 of the Costa Mesa Municipal Code, franchises and planning, zoning, and development, relating to wireless telecommunications facilities and related infrastructures within the public right-of-way. This item was continued from the November 25th, 2019 and the December 9th, 2019 Planning Commission meetings.
Okay, thank you. Commissioners, I just would ask if in the interim from our December 9 meeting, if you've had any ex parte communications with anyone. Commissioner Zick is, yes, sir.
Yeah, I've had a telephone conversation and some email exchange with representatives of the Costa Mesa Advocacy Group.
Okay, anyone else? Commissioner Colbert and then Commissioner Perkins.
Similar email communications with the Costa Mesa Advocacy Group, which is represented here tonight.
Okay, Commissioner Perkins.
Same thing, an in-person meeting with with Monica and Allison of that group.
Okay, anyone else? Okay, and I've had a meeting with representative of the Costa Mesa Advocacy Group as well in the last few days. So having said that, Mr. Porter, I'm going to ask you to kind of reiterate your kind of caveat as you did in the December 9 meeting before we get going.
So this is a reminder to the public and to the planning commissioners that federal law prohibits a city from taking action on wireless telecommunication matters to the extent that a proposed application would comply with federal FCC radio frequency emission requirements. So if members of the public want to talk about items or if you want to consider items that are within our purview, that would certainly be appropriate. But because we cannot legally take those into account, if members of the public do talk about radio frequency emissions, now what we can do is we can take actions, and this ordinance does propose actions to ensure compliance with federal law. But if what is being proposed is consistent with federal law, then we can't regulate further.
Okay, thank you. Ms. Lee.
Thank you, Chair and members of the Planning Commission. Jennifer Lee, Assistant Director of Development Services. Since we had a full report on this item at the last meeting, my report this evening will be an abridged version that will just focus on the basic background as well as the issue before us this evening. Wireless regulations locally really came to the forefront in 2010 when a telecommunications facility was installed on the top of a wood pole within the city's right-of-way, located near the intersection of Tustin and 20th Street. At that time, there was no authority in the municipal code to review such facilities, and an encroachment permit was issued. Residents of the adjacent neighborhood expressed concerns, and as a result, the city adopted an ordinance requiring the equivalent of a minor conditional use permit for any proposed telecommunication facility that did not meet certain criteria. Since 2010, an MCUP has been processed to install a wireless facility within the public right-of-way if it meets certain criteria. The city received our first small cell application in late 2017 and immediately after began on design guidelines. Because much of our procedures that are proposed per ordinance this evening are driven and limited by federal and state law, I will give a brief overview of some of the federal standards that apply. First, the city regulates wireless facilities through its municipal code, but we do it under the umbrella of federal and state law. At the federal level, the FCC governs what local jurisdictions may consider in their review of small cell facilities. Per federal law, the city may not regulate the placement, construction, or modification of wireless service facilities in a manner that prohibits or effectively prohibits the provision of personal wireless services. However, federal law does not prohibit the city from considering aesthetics and facility location, so long as the criteria used to evaluate the facility are reasonable, non-discriminatory, objective, and published in advance. In addition, on January 1st, 2016, California Assembly Bill number 57 became effective, which provided that applications for co-location or siting of a wireless telecommunications facility be deemed approved if a city fails to approve or disapprove an application within 90 days for co-location and 150 days for a new wireless telecommunications facility. In September of 2018, the FCC adopted Order 18-133, which became fully effective in April of 2019. The main effects of the regulations were as follows. First, the shot clock deadlines to approve or reject the deployment of small cell facilities in particular were shortened to 60 days for co-locations and 90 days for wireless facilities on new structures. In addition, the FCC included all processing, appeals, as well as permit issuance within the totality of that shot clock. The FCC limited the application fees a city may charge to a reasonable approximation of actual costs, so long as those costs are reasonable. There is no set definition of what reasonable might mean, but the FCC indicated that a safe harbor for fees is $500 total for up to 5 applications and $100 for each application after that. The definition of co-location was expanded to include new installations on existing structures, regardless of whether those structures already have existing wireless facilities on them. Lastly, the FCC prohibited local government aesthetic standards for small cell facilities unless they are reasonable, no more burdensome than those applied to other types of infrastructure deployments, objective and published in advance. Regarding RF emissions, federal law prohibits local government from regulating wireless facilities on the basis of perceived health effects of radio frequency emissions. The city requires an RF emissions analysis and report as part of our MCUP application for wireless facilities. We do that as part of our existing procedures. The report is required to be prepared by a licensed engineer and to demonstrate compliance with FCC standards. The city also requires, as a standard condition of approval, for post-installation measurements and reports to confirm compliance. In addition to federal law, there is also pending legislation regarding wireless facilities. H.R. 530 and SB 2012 are being considered and state that the 2018 FCC ruling shall have no further force in effect. If passed, the legislation could roll back the FCC's 2018 ruling, which, as you may recall, primarily relates to shorter shot clocks and limited fees a city can charge. Costa Mesa has signed on to the National League of Cities letter in support of that legislation. Our city attorney's office has also submitted letters to the FCC opposing their recent proposed changes to Section 6409 of the Telecommunications Act and their proposed revisions to the over-the-air reception devices, or OTARD rule. The 2018 FCC ruling is also the subject of 10 local government lawsuits that are ongoing and consolidated in the Ninth Circuit Court of Appeals. Again, these lawsuits are focused on the 2018 FCC order, and that has primarily to do with shortened shot clocks and the fees that a city can charge. This is a website that the National League of Cities has posted online. It contains a Word version of a letter that supports H.R. 530. This is a website that members of the public can visit and submit their comments online to support the legislation. The city first adopted design guidelines and has been working on this issue since late 2017, early 2018. Most recently, the City Council held a study session on August 13th, 2019. The study session and community open house was held here at City Hall, and there were 8 public comments received at the meeting, as well as a number of email correspondence. Staff discussed the potential for modifying the city's design guidelines at that time with the City Council, and discussed specifically including a locational hierarchy, a residential setback, as well as alternative support structures other than Southern California Edison poles. The City Council requested staff return with modified design guidelines and to evaluate a number of possibilities that they outlined at that study session. Staff returned to the City Council on October 1st, 2019 with modified design guidelines and held a series of public hearings and received a number of public comments as well at that time. The council did approve design guidelines on October 1st, 2019, and those design guidelines addressed preferred support structures, the locational hierarchy, additional locational standards, as well as design specifics like finish, noise, landscaping, the requirement for a streamlined design, as well as requirements to underground equipment. At that same time, council also directed staff to begin working on a code amendment that would specifically streamline the review process to allow the city to meet federal shot clocks. They also established codified application requirements and standards as something that they wanted to see as part of this ordinance. Council expressed an interest specifically as part of the ordinance that location should not disrupt the path of travel, that there should be some resident notification of any future facility upgrades. They were interested in seeing any ministerial approvals posted online for public information. They were interested in seeing a requirement for a post-installation RF report, as well as staff to evaluate whether we could include a clause for reevaluation of any approvals if there were changes in law. That was the specific direction from council at the time that they adopted the design guidelines for what they expected staff to move forward with tonight's code amendment. As I've alluded to previously, this is part of a multi-part effort. The first step was the revisions to the design guidelines that really focused on the specifics of the aesthetics and location standards. Tonight is the subject of the code amendment, which addresses the review process, specifies application requirements, review criteria, and also standard conditions. Our third step is, after the adoption of an ordinance by City Council, would be to update the city's website and materials and our practices and to post as much information as we can online. So the code amendment process, just to be clear on the steps that are involved, anytime that the city modifies our municipal code, it's really a four-step process. The first is a recommendation from the Planning Commission, and that's the subject of this evening's hearing. If the Planning Commission recommends moving something forward to the council this evening, the next step would be a first reading of that ordinance by City Council. There's also a second reading by City Council, and following that, the ordinance becomes effective 30 days after the second reading. As to the specifics of the proposed code amendment, it is an amendment to Title 19. The code amendment is intended to complement the design guidelines that were already approved by City Council by addressing specifically the review process for wireless facilities, application requirements, review criteria, and standard conditions. There's also a very small change to Title 13 that includes a cross-reference to Title 19 for completeness. This slide outlines the existing review process for wireless facilities in the public right-of-way. The proposed review process would establish a wireless telecommunications use permit and require such a permit for any facilities in the public right-of-way. There is a ministerial approval process for small cell facilities that meet code requirements. That would be a director-level decision. Those decisions are posted online, and they would be appealable to the city manager, as all ministerial decisions are. If the application is a discretionary review, which means that some of the code requirements are not met, there would be a public notice 10 days prior to the decision. The notice would be mailed to a 500-foot radius for property owners and occupants within a 500-foot radius of the proposed facility location. It would be a director-level decision. Again, those decisions would be posted online and appealable to the city manager. The proposed review process also codifies requirements for eligible facilities requests. These are specific types of requests that are outlined in federal law that are really modifications to an existing facility. The proposed code amendment outlines very specific requirements for those types of changes to an existing facility. An encroachment permit would be required. Those permits, when issued, would be posted online, and the codes include specific application requirements and standard conditions that would apply to those encroachment permits, and those include RF emissions reports. In terms of Planning Commission's review, the Planning Commission first saw the subject ordinance at the November 25th, 2019 meeting and continued the item without discussion to December 9th. On the December 9th, 2019 Planning Commission meeting, testimony was taken, and then the item was continued to allow additional time to consider public comments received. Staff has modified the ordinance as shown in the staff report, and the staff report also addresses the main issues that were raised in the public comments. With that, staff concludes our presentation. We are recommending that the Planning Commission adopt a resolution recommending to the City Council, first, find that the ordinance is exempt from the California Environmental Quality Act, and second, that the Council adopt an ordinance modifying the municipal code with respect to wireless telecommunications facilities and public right-of-way as described in the staff report. That concludes my presentation, and I'm happy to answer any questions. We also have Mr. Porter from the City Attorney's Office as well, and John Willie Glupos, who has been instrumental in preparing this ordinance. Thank you.
Thank you, Ms. Lee, and thank you, Mr. Porter and Mr. Glupos, for all your work on this. And staff, I also appreciate your patience on the kind of ongoing deliberations on the topic. I appreciate it very much. Commissioners, are there any questions of staff at this point? Okay, Commissioner Zick and then Commissioner Perkins.
Okay, thank you, Mr. Chairman. So I'll start, I only have a few questions. Starting on handwritten page 4, I want to make sure I understand the language in this Title 47 of the code, under paragraph A, the little phrase that says, relative to what we can regulate, shall not prohibit or have the effect of prohibiting the provision of personal wireless services. So my first question, about that phrase has to do with the level of service or quality of service. So if in an area of the city where a proposed cell tower is applied for, if there's already wireless service in that area, could the application for that tower or that small site be not approved because there is already service, or is there some open-ended right to a carrier to provide any level of service they want above an existing level of service?
So the city does retain the authority to regulate within boundaries. So historically, until recently, the standard has been that if a city, if there is a quote significant gap in a cell phone tower coverage, then they have the right to fill that gap. Okay, what's the significant gap? The FCC changed that test and made it more beneficial to wireless carriers. And the FCC in the 2018 declaratory ruling said that now the standard is whether the city will be materially inhibiting the deployment of personal wireless services. So if, again, that's a fuzzy standard, but that's the test. So it doesn't mean that they automatically get everything that they want, but if we're making it extremely difficult, we certainly cannot do that. Now, maybe we can say we will allow wireless coverage. You can supplement your existing infrastructure, but maybe not there, do it in this way, change it this way, et cetera.
So if they have a location, make sure I'm understanding you, if they have a location they're applying to put a small cell site, and we know there's service in that area.
So, right, I understand the question. So simply because they have service does not in and of itself establish whether the city is materially inhibiting a particular deployment. Think of this as it's no longer a coverage issue because frankly everywhere in the city can receive some level of wireless facility cell phone reception. Think of it this way. Right now you have a freeway of 2 lanes. And what they're saying is we have massive traffic jams. Yes, there are freeways that cover the entire city, but we need to expand the freeway to 8 lanes because during crunch times, you have massive traffic jams and people there's not enough infrastructure there to cover the demand. That is the reason that telephone corporations wish to deploy more infrastructure and to duplicate. So the question is, how much duplication is necessary? Must we always allow it? Certainly not. There are limits. It's very much, I can't give you a specific answer. So we do have the ability to deny sometimes, but we can't go too far.
Okay, I'm going to pick at that a little more with another question, but let me go on to some other words in there. It talks about personal wireless services. I'm assuming that means voice and data, and the reason why I'm asking that question is because we got some correspondence from the public that suggested that the small cell towers only provide data and not voice. And so my question is about the United States Code. Is it speaking to both data and voice?
It does speak to both, and quite frankly, the overwhelming majority of traffic is it's data. And frankly, the way that technology is working with everything being, it's no longer analog, it's computer driven. They don't care what information it's sending, whether it's voice or gaming or you name it. It's just a packet of information.
Okay, and still focused on this paragraph, suppose a small cell site is approved in a neighborhood by carrier A. And 6 months later, another application comes in from carrier B for another pole nearby where Carrier A has just established a site. Could it be argued by the city that that second site won't be approved because there's already service to that neighborhood via Carrier A?
So we cannot prohibit one company from providing service because another company is providing service. Effectively, that would be prohibiting somebody from deploying, it would be a monopoly. You're saying, oh, sorry, nobody else is allowed into the city because we've already built here. So the rule is we can consider a particular company's infrastructure, but we have to ignore what infrastructure already exists for other companies.
Okay. My next question, thank you for that, I think. My next question has to do with the conformity with the FCC guidelines on emanations for the post-installation testing.
Sorry, let me clarify what I said.
Okay.
So we have the right to consider aesthetic impacts. And the city could consider that it would be aesthetically displeasing to have a number of facilities immediately next to each other. But that's not based on who's controlling the facility. You follow me? We could say there are too many facilities in this neighborhood. We're regulating based on what they look like. I don't care who owns what facility, if that makes sense.
Well, it makes perfect sense, and so that raises a question I didn't have but now do.
Okay.
Do our guidelines contain any language anywhere that suggests that that is one of the considerations we'll make in reviewing the aesthetics of an installations application?
In the design guidelines, the council approved a separation between facilities as long as they're the same company because of this non-discriminatory clause of federal law. So that's one way that it's addressed, the topic is addressed. There's also review criteria that are outlined in the ordinance themselves that speak to compatibility and aesthetics. So that's the second way that it's addressed. And I can find that page number and come back to you.
Okay, so what I was trying to envision from what you were describing, and I'm trying to square that with what you're explaining, is that on a residential street that might have a couple of blocks long, 3-4 streetlights, if there were 2 or 3 cell providers that wanted to put towers along that 2 or 3 block stretch, one person might say the aesthetics of that are no good, and so we shouldn't do that. And what I'm wondering is if our design guidelines give us clear authority to not approve an application based on that.
So the point you're bringing up is interesting because
Oh, you brought it up.
well, I'm glad I interest myself. Anyway, so really there's 2 sets of issues here. One is what our code allows us to regulate, and the other one is what federal law mandates. So certainly we can take into account aesthetics, but if our regulations go so far as to effectively prohibit a company from deploying sufficient infrastructure, then our rules would be illegal. So you would need escape hatches within whatever rules we have to make sure that we're not violating federal law.
Got it. Okay, that's a good answer. So the question I'm referring to in my notes is on handwritten page 42, and it has to do with the RF compliance testing. A member of the public, I think, said that the permissible exposure limits were established in 1996. Is that correct?
Originally, as part of the Telecommunication Act of 1996, there were standards that were adopted. They have subsequently been, I don't remember all of the dates, but they've been periodically reviewed and updated. Just recently, as of maybe a month ago, the FCC expressly declined to take action to further amend the applicable RF regulations.
So
So
would you know how recently those have been updated?
I don't recall offhand. It's been a number of years, but I don't know the exact answer.
Okay. And then my next question, and I am winding down, has to do with this idea of the gap in coverage as a basis for a provider being approved to establish a small cell site. Just because they want to put one doesn't give them the right to, provided that there is already sufficient service in the area. And by not approving it, if that didn't prohibit the providing of that service, we'd be within our rights to not approve it. Just because they want one doesn't give them the right to, correct?
That is correct.
So what is the basis, what data, what information do they need to provide to the city in an application that establishes the need to establish a small cell site? You talked about significant gap as a standard previously existed, no longer exists. You mentioned the concept of materially inhibiting. So can you explain to me what it is that a provider needs to demonstrate in terms of a need?
So generally, the proposed ordinance, actually maybe you recall, okay.
So there's a number of application requirements that speak to need. Because significant gap is not a criteria that we can really use, we have asked for as part of the application requirements that are in the subject ordinance, a project narrative and justification as to exactly the need for the facility. The exact evidence that is to be presented, I think, is a bit of art and a bit of science. But at the end of the day, what we're looking for is a sort of clear and concise justification for why that facility is necessary in that location. I think it is important to understand as well that the carriers have information as to their data and their models and their customer demand. The city does not have access to those. So our review is focusing more on, does the facility meet the requirements, and is there a clear and concise need articulated in the project justification? Significant gap is not a main criteria for an application to be accepted.
Okay, so if we received an application and for whatever reason, city staff reviewed it and said, nah, I don't think you've established sufficient justification for this, so we're not going to approve it. Presumably, the carrier would disagree with you and come back to you. So I'm wondering, in that dialogue, how it is they're going to demonstrate to you the need and how it is we're going to be able to understand and rationalize that need.
It's a good question. I think that from staff's perspective, it's not something that the city can independently do an analysis of and review. This is the type of thing that we would be hiring a consultant expert to work with the carrier to determine whether they have demonstrated the need. It's not something that the city has the data to independently verify.
Okay, so I'll accept that. And so then on handwritten page 50, it talks about this site selection plan, and it says, and by the way, this is new language you've added since our last meeting, and I think this is excellent, and I do want to applaud you for the effort of incorporating all the different concepts and ideas and inputs that you've received, and this, I think, was one of them. Identify on a map all potential support structures within a radius of 500 feet from the proposed project site and provide clear and convincing evidence that the alternative support structures are no more preferred. So I like that in a way, because that is saying that as part of the application, when they say they want to site the small cell site on this pole, part of what they need to provide is a map of all the other poles within 500 feet and a clear and convincing evidence as to why those are no more preferred than the location that they have selected. So then this leads into my question. So I'm a resident and I'm not paying particular attention to what's going on. I'm not hitting the city's website on a regular basis. I've not bookmarked the page where these decisions are posted and maps exist and that sort of thing. Just kind of minding my own business. And I'm wondering if a light pole near my home has been identified by a carrier for a small cell site. How am I going to find out about that? And if it's a ministerial or it's a discretionary, if you could describe possibly the difference. I'm just living in my house and there's a pole outside. I don't want to one day have a truck show up digging a new foundation for the new pole, and at that point become interested in talking to the decision maker or trying to appeal it, because by that time I'm sure I'm well beyond any appeal period. So my question is, I'm minding my own business, not paying attention. How am I going to know that pole outside my home has been applied for a small cell site?
So there are two categories of wireless telecommunications use permits. There's the ministerial permit, and then there's a discretionary permit. The ministerial permit is one that is given when a facility literally meets all of the requirements of the code. That includes the setback from the residence, that includes other location requirements. It includes all of the criteria that we've listed in this ordinance, and they've proactively demonstrated compliance through their application. If they meet all requirements, then it's a ministerial approval, and in that case, once the approval is made, it's posted on the city's website. A discretionary wireless telecommunications permit is different in that there is something about the facility that does not comply. It's closer than our standards indicate to a residence. It doesn't meet the preferred support structure requirements. There is something about it that does not comply with our code. At that point, it becomes discretionary because the city is considering other facts as we're deliberating about whether to approve or deny the application. When that's the case, there is a notice that is delivered to all property owners and occupants of properties within 500 feet of the proposed location at least 10 days before the decision is made, so that they have the opportunity to comment on the proposal. When a decision is made on that site, it is again posted online, and the decision date will be in the hearing notice, so the community is aware when that decision date is, as well as the appeal period for that decision. That information is posted online as well.
Thank you for that answer. So if I'm a resident who is maybe keenly interested in these types of facilities, but not paying attention, and an application comes in that requires a discretionary approval, I'll receive in the mail a notice. But if the application is compliant with all requirements and would result in a ministerial approval, I wouldn't know that is even going on, the way the ordinance is currently written, correct?
Correct. We will post applications when they're received on the website, but of course, you would need to look at the city's website.
Is there tell me what problem might be involved, or what complexity in the process would be introduced if we also had the 10-day noticing, if we had that for all applications, regardless of whether the approval was ministerial or discretionary?
So a couple of just practical points. The city issues many types of permits and approvals that are ministerial. It's why we adopt ordinances and very specific requirements, because there needs to be an opportunity for really anyone to be able to build something that complies with the city's code and have a fairly streamlined process to do that. Otherwise, everything is discretionary and everything goes through a more sort of scrutinizing body, even when it meets the city's requirements. So that's the practical part of it. The city issues building permits, grading permits, encroachment permits. There's a number of permits that are issued ministerially. We do not notice within a 500-foot radius every time we issue a building permit in the city, for example. So from the standpoint of consistency with noticing procedures for other ministerial approvals in the city, that's a consideration as well.
So that's fair. I think the reason why I asked the question and the reason why I put this together with my previous comment about the paragraph on page 50 is because I'm thinking that if I received notice that a small cell site was going on the pole outside my house, all of a sudden I'd be very interested in knowing all the other poles within the 500 feet from that one, to what extent there was clear and convincing evidence that none of them would be more preferred. But I wouldn't have the opportunity to do that because I wouldn't have a clue that an application for a small cell site that's going to result in a ministerial approval is being considered until that approval has been posted on the website. And then from the moment it's posted on the website, I have presumably 7 days to appeal that, correct? Which means I need to be hitting the city's website every single day in order to protect myself, if I'm paranoid about this, to protect myself against the pole outside my house getting a small cell site approved for it.
3 business days, correct.
3 business days. Okay. That answers all my questions. Thank you very much. Thank you, Mr. Chairman.
Commissioner Perkins, and then anyone else after Commissioner Perkins have a question, and then Vice Chair Harlan.
Thank you very much. An excellent presentation, and many questions got answered through that, so thank you very much. I actually wanted to talk, interestingly, my first item was talking about the appeal timeline and a couple of issues with that, which is on page 16 of our packet, or hand-numbered page 16, I should say. And so the first question comes in. It's section or numbered item 3 on that page. Notwithstanding municipal code section 2-305, an application must be for appeal must be filed within 3 calendar days after the date. And so I wanted to get clarification and understanding on why we changed that from the default 7 days that is included in section 2-305.
So the reason is because the federal shot clock requirements are extremely limited. So for small cells, you could have as little as a 60-day turnaround for the city to take action on a small cell facility. And that's inclusive of issuing building permits, encroachment permits, more than just planning staff. And it is not clear whether that also includes appeal time. And if it includes appeal time, well then shoot, you've got an extremely abbreviated time frame. So that's the reason for the shortened time frame.
Okay, so the 3 days is shortened down due to that shot clock concern.
Correct.
I understand that. The next question I have is section 2-305. We're saying it's notwithstanding that, so we're overriding it. That section also has a clause about what happens if that appeal deadline falls on a weekend or holiday. And so that was one of my concerns, is if we have, say, only 3 days, if the ministerial approval happens on, say, a Thursday, then that third day would fall on a Sunday, and we can't, the section 2-3, other section portions of section 2 say it has to be filed in person. So there's a section in 2-305 which says if the final day for filing an application for appeal or review falls on a holiday or weekend day when City Hall is closed, the application shall be filed no later than the next business day. I wanted to find out if by saying notwithstanding municipal code section 2-305, are we overriding that as well? Because I'd be concerned about people not being able to turn in an application
Right.
for appeal.
I don't think that it is a concern because it only is specific to those 3 days. It's saying ignore the 3 day, we're overriding that portion of it, but if you want to add language into, parrot that exact language, I would have no objection to clarifying that concern. I think that's totally reasonable.
Okay, so we could add language saying something like, in that, basically copying over if the final day for an application appeal review falls on a holiday or weekend day, would be
Correct.
filed next business day.
Yes.
Okay, great. And so the other question I have is on page 23. It's regarding the landscaping conditions, and I think some of these got changed a little bit in response to some of my comments from last time, so thank you for taking those comments into account. My comments last time I was especially concerned about, there was a section in the code that said we were requiring any trees damaged be replaced with a tree of the same size. And my concern with that language is sometimes if you have, like, say, a giant ficus that's maybe 80 feet tall, you might not even want a tree that's 80 feet in that region. So that has been removed, and I appreciate that. One thing, and again, I've been sort of looking at the interaction with other parts of our code. Chapter 5 of Title 15, which talks about parkway trees, which we refer in this section on landscaping. We say that it must be made an appropriate location for the species, subject to Chapter 5 of Title 15. Chapter 5 of Title 15 includes a section, it's 15-139, that actually has a blanket exemption that excludes all of that section on landscaping for public utility companies. So would a small cell installer thus be exempt from our landscaping concerns that we have here? Because I would want them to, if they damage a tree, I most certainly want that tree replaced.
Chapter 5 of Title 15 describes the process that any person has to go through who modifies or removes tree or landscaping within the public right-of-way, and that includes review by the city's arborist, a requirement to submit a landscape plan and replacement plan, as well as review by the city's Parks Committee. That is intended to be the process for any wireless facility in public right-of-way that proposes to modify landscaping. And for purposes of this ordinance, although small cell facilities and wireless carriers in general are overseen by the California Public Utilities Commission, they are not themselves a public utility.
Okay, great. So they would be held to that section.
Correct.
Thank you very much. And I think those are all of my questions for the time being. Thank you.
Thank you. Vice Chair Harlan?
Thank you, Mr. Chair. I only have one question, or hopefully one question, and I'll direct you to handwritten page 70. This is section 3, the design guidelines. So this is a new edition, and my reading of this is that by adopting this ordinance, the design guidelines are essentially part of the zoning code. Is that correct?
They would not be published within the zoning code, but they would be, in effect, they would be law.
Okay, so I want to ensure, as far as expectations are concerned, that if there are changes to the design guidelines, that they still do maintain that force of law, even if they're done by, for example, resolution, as it says here.
So this is drafted so that it allows the flexibility of the city to revise them based on either ordinance or resolution in the future, so that it is not mandatory that very minor technical clarifications go through this entire amendment process.
Okay, thank you.
Okay, I have a few questions. Let me find my... So I guess first question I have would direct staff's attention to handwritten page 7 on other permits and approvals. And essentially the gist of that provision in the ordinance states that any application for ministerial permits related to the installation of a wireless facility must have those permits, must have the wireless telecommunications use permits as part of the application for the ministerial permits. Am I reading that correctly? So in other words, the WTUP has to be approved before they can go get the other ministerial permits. That's the way I'm reading
So you
that.
still need to comply with every other provision of the code. So for example, you can't cut down a tree unless you have spoken with Public Works, et cetera.
I know, and not the question. What I'm reading
Okay.
is, I'm trying to understand the order of operations here. I have to go get my WTUP before I apply for all the other ministerial permits. Is that how I'm reading it?
That's correct. It's intended, the WTUP is first, after is the encroachment permit. And those are the two main permits that are required anytime in public right-of-way for wireless installations.
Okay, so the reason I asked that question is relative to the shot clock and appeal period. Why would we not require that they get all their ministerial permits first before they come in and apply for a wireless telecommunication permit?
Encroachment permit requirements, typically an encroachment permit is required anytime there's access provided to the public right-of-way. It's something that in the city is typically over the counter. In this case, because it's for wireless installations, we want to go through the more specific and arduous process first of vetting the facility, and after the encroachment permit would be more typical of the encroachment permit, which is a more straightforward process.
So could you have a process where you conditionally approve the ministerial permits contingent upon the approval of the WTUP?
You could, but typically the difficult issues are going to be vetted in the wireless telecommunications use permit, so we want to ensure that it's a viable application that meets all of our requirements before we go through the process of doing essentially a plan check at encroachment permit time.
Okay. All right. Mr. Porter, regarding so the only context with which we're permitted to consider RF emissions is in the context of the FCC's regulation that says you can consider them only within the context of what we allow.
Correct. So what we can do is we can take steps to ensure that what is being proposed actually is in compliance with federal requirements, but we can't change federal requirements.
Of course. So I understand that. So in terms of the post-installation, I'm going down to handwritten page 19, the post-install certification. And it's actually on handwritten page 18 it starts. So within 60 calendar days, the permittee shall provide the director with documentation reasonably acceptable to the director that the wireless facility or other infrastructure deployment has been installed or constructed in strict compliance with all the guidelines. Such documentation shall also include a report from a licensed electrical engineer, parenthetical qualifications, confirming that on-site RF testing was completed after the permittee commenced full operations, and which testing confirmed compliance with all applicable RF requirements and the RF compliance report. My question is, in other elements pre-installation, we're requiring that they do an assessment of the unit to be installed and the cumulative emissions nearby. I think it's like, so are we requiring also a cumulative examination in that post-certification install?
Correct. That is part of the test. So there's two steps. Step number one is promise that what you're going to build will comply. You've designed it in such a way that it will comply. And then step number two is ensure that it actually does comply. And part of that testing is required to take into account not only the amount that you are emitting, but from all sources,
Okay,
the cumulative effect.
right, okay. Now, there's been some questions from the public and actually requests from the public about regular checks beyond just the post 60-day certification or the post-certification 60-day check. And from my reading and some research I've done is basically the courts have said regular checks are not permitted. Checks can only be performed, and I could be wrong, it says when there's reason to expect non-compliance. So how would we know, how would we have reason for non-compliance if we stop checking these things after 60 days?
So if, for example, there was a traffic accident and the pole was hit and there was substantial damage to the pole and maybe there was some damage to the equipment, that may be a reasonable time to say, hey, there's a reasonable belief that there may be some malfunction. Of course, it's going to depend on the facts and circumstances, but if there is a reasonable basis for that, then we can certainly do a check at that point.
Okay.
The FCC has ruled that a city does not have the ability to regulate the operations of a facility. So that, I think, is probably the basis of the law that you're citing.
Okay. Ms. Lee, what would be the effect essentially of extending the proposed setback 25 feet from the nearest residential structure of any of these facilities? What would be the effect of extending that distance beyond 25 feet? Making it further.
25 feet was established as part of the design guidelines as a reasonable setback from from a residential structure. There was a lot that went into determining what was reasonable. From a practical perspective, it's very important to set standards, one, that are reasonable and capable of being met. If you look at the distribution of residential properties in the city, they're the majority of the city is covered by residential zoning, with just major arterials that are designated for commercial and an area north of the 405 for industrial and other small pockets. So when you really look at the distance from residential as distributed in Costa Mesa, if you go much beyond 25 feet, you're really hitting the majority of the city.
So you're effectively prohibiting the installation of small cell sites in residential neighborhoods.
Exactly. You're making it such that every application is a discretionary review. That would be the practical result, is that every application would be a discretionary review. And more than likely, because effectively prohibit is the standard, we would end up with the exact same result. Whether it's ministerial or discretionary, we would just have more applications going through the discretionary process.
Okay. Regarding separation of facilities from a single carrier, which is 500 feet in the ordinance, why is that the number? Why isn't it 1,000 feet? Why isn't it 250 feet? Why isn't it 750 feet?
The 500-foot separation was established by council at their October meeting as part of the design guidelines, and it was after a discussion at that meeting. The 500 feet was landed on in coordination with the city attorney's office as something that was a reasonable distance, again, without effectively prohibiting service. It had to do primarily with the service capabilities of most small cell equipment.
So just as a general observation question, a built-out city would have trouble probably requiring 1,000-foot separation versus a rural community where a pole for mounting might be 1,500 or 2,000 feet apart. And short of erecting a new pole, it'd be impossible to have facilities closer than 1,000 feet?
That's correct. It has a lot to do with how residential zoning is distributed in the city and the density of a city. Every city's geographic characteristics are going to be a little bit different, but looking at Costa Mesa's, we proposed something that we thought was reasonable and achievable.
Okay. Mr. Porter, nothing precludes the city, so we know there's ongoing litigation relative to the courts deciding the extent to which cities can regulate these. I figure that's what these lawsuits are about. So depending on the disposition of these suits and where they come out, there's nothing that precludes Costa Mesa from revisiting this ordinance at some point, and indeed, if the courts grant local jurisdictions more authority to monitor or regulate these facilities, we could certainly come back and modify the ordinance to do just that.
Yes, the Planning Commission and the City Council have the authority to begin a revision of the code at any time.
Okay. Anyone else? Questions of staff? Commissioner Tourget, I'm sorry.
Hi, thank you very much. I just want to let you know that I reviewed the previous meeting and read the materials in detail, and I have a couple questions tonight. The first is on page 5 of the agenda report. There's the definition of technically infeasible written. And I was wondering if staff can walk through the process of what finding something technically infeasible or technically feasible is, and whether or not that relates to the site selection plan on page, handwritten page 50.
Could you say that handwritten page number one more time?
Handwritten page 50, Commissioner Zick mentioned it earlier. The site selection plan includes identify and map all potential support structures within a radius of 500 feet.
So we have included a definition of technically infeasible. If you will give me a moment to find that page number, and then I'll come back to you.
Okay, I see the definition on page 5 of the blue of the staff report. Pardon me, but I just wanted to know what the process was for identifying what staff would view the process that was for identifying what is technically feasible or technically infeasible.
Got it. I see what you're looking at. Thank you.
Thank you.
So we've specifically defined technically infeasible as having to do with sort of physical characteristics, because primarily what we're looking for is that the site map identify all possible structures within 500 feet so that we can evaluate whether there is a physical possibility for the facility to go in another location.
Mm-hmm.
That's primarily having to do with one, the setback requirements, the location requirements that are already in the design guidelines, but two, is it, for example, is there an ADA sidewalk with conflict that would make putting a facility in that location physically impossible?
Mm-hmm.
So that is really what we're looking for in that site review map and with that definition of technically infeasible.
Okay, great, thank you. And then the next question I have is just reviewing the changes that have been made over the last few months. Has the staff incorporated, does staff believe you've incorporated public comment into the revisions to the ordinance, as well as Verizon and AT&T's response? I'm wondering if it's something staff believes is fair and balanced.
We do believe it is fair and balanced. Staff have met with both the wireless carriers as well as representatives of the community multiple times to really understand their concerns regarding the ordinance. We went item by item from each one of the letters that was received and really evaluated whether it was something that we felt we could reasonably include in the ordinance. We included everything that we felt was appropriate, and for the things that we did not feel were appropriate, we didn't make the changes, but I did try to highlight those in the staff report so that you could get a good feel for what we included and what we felt wasn't necessary in the ordinance.
Okay, thank you.
Thank you.
Okay, I'm sorry, I had one more question, and I hope I can remember it. It's just awful getting older, I swear. And I can't, but I'm sure I'll remember at some point. So what I will do is open public comment. For this continued public hearing, anyone wishing to speak to this item, please come forward to either one of the podiums. And if you would, you don't have to, but if you would state your name for the record for the benefit of our stellar clerk who needs to do the minutes. You are stellar, Julie. Yes, ma'am.
Hi, good evening. My name is Monica Dragesi, and I'm here representing Costa Mesa Advocacy Group. We will have some additional comments. We decided to split them up, but I do want to point out a couple of areas that are still not consistent with public expectations that are clearly within the purview of the city to monitor. First, the inclusion of macro cells in a ordinance that is supposed to be dealing primarily with small cells. We have pointed this out before. It is confusing language and it is poor drafting. The FCC treatment of these facilities is different than small wireless facilities. There are no shot clocks. The shot clocks are different. So unless Costa Mesa is planning to erect and approve a bunch of these in the public right away, this cannot be in the same ordinance. Our suggestion is that these requirements be incorporated into the city code where they came from. This is the situation, the example where this language was included because we had no such protective language for the macro cell at 20th and Tustin. There is also no inclusion of on-strand mounted cells. There are transmitters being installed all throughout the city. I have a couple of examples by me on Baker between Mesa Verde and Labrador Drive. My suspicion is that these are not wireless providers. These are cable companies that in effect are doing the same thing. They should be subject to the same standards. They're kind of lumped into the other category, but field testing, RF testing, all of that needs to occur. We also are experiencing a loss of revenue because we're not collecting from any of those on-strand mounted cells. The notification, I know that there was a lot of discussion from the Planning Commission on that, and we appreciate all those questions. Ministerial review does not allow for any persons that are impacted by a radiation that are required under the ADA and the Federal Housing Act to have due process. So I'm not sure how that is going to be addressed by the ordinance. Discretionary review process, appeal of 3 calendar days. I know that we discussed about that. We have seen other ordinances by other cities that somehow manage to meet the shot clock requirements and give sufficient due process beyond 3 calendar days, which I don't think is reasonable. And I do want to understand how a normal common person who is not familiar with all this intricate subject would know what is happening, and other than checking the city website every single day. A couple of other points. The Telecom Act did mandate EMF standards. It has not been updated since 1996. I know that was discussed earlier. The FCC did indeed choose to bypass that last month and basically upheld that the same standards should apply. The other item that I wanted to clarify is not sure what clear and convincing evidence means. Also unclear what will trigger a third-party review by a specialized consultant. It's interesting that there is a Wall Street Journal article that came out a couple of years ago. They randomly reviewed 5,000 cell sites throughout the United States. 1 in 10 were actually emitting at levels that were unlawful. So I don't know how we're going to make sure that that doesn't happen here. I think those are all my comments. I did have one other thing on landscaping. I appreciate Commissioner Perkins' comments on that. I do think that cutting down mature trees may significantly impact the aesthetic of the city, the green the greenery that we all are enjoying. So I would like to have some consideration about that and maybe not replacing them with shrubs. Those could be mature trees that are beautiful, but we may not want the same species.
Okay, thank you, ma'am.
Thank you.
Yes, sir.
Good evening, Commission. Jay Humphrey, Costa Mesa resident. I want to thank you guys. You guys have been asking all the questions that are on my list, so we don't have to go through those again. I appreciate the fact that everybody is worried about this problem, as they should be. We're dealing with the health and safety of Costa Mesa residents, potentially. Having said that, we apparently are looking for them to document the poles in a 500-foot radius of the pole they're going to put in. Do we have, right this moment, a map that shows where every cell pole in Costa Mesa exists? I wonder about that, because if it does, I can't find it. Maybe it's hidden in the bowels of something that exists somehow and you get to it on website somehow. But as has been a problem before on multiple other issues, trying to find a piece of specific data that would be germane to the public sometimes becomes fairly hard to find. So I would really like to find out if, in fact, and I would be appreciative if staff could send me an email to show me where that spot is, that exists. With that in mind, it would seem to me fairly simple, two things. First off, rather than sending out notices, which I think is important things, but they should be required also to tag the specific pole with a notice, just like when somebody's building a building or what have you, a notice goes out front and says, hey, we're going to be doing changes here that require approval. So they should be required to notice the pole. To your specific question about how do I know the pole in front of my house is going to get something on it, that's a way for us to know that way without having to worry about going in and out of the city council, which I think is a great hindrance to the public. I think the public needs to get every break on these kind of things, especially in this setting. And the last thing we're talking about is the RF studies you're doing. The RF study is only done once, except if they put another pole, 500 feet away, 200 feet away, 60 feet away, 180 feet away, whatever the dimensions happen to end up, then you take the RF emissions of that pole relative to the total, and then you have another one, you take that to the total. So we get a continuous data of emission levels going on. And what do we do with that data? We just take it and throw it in the file and say, forget about it? Or do we become Love Canal? Because quite honestly, a lot of people are aware of different contaminations in the soil, but all the reports kept getting stuffed in the thing. Detroit's another place, but the reports got stuffed into different places and never went to anything to look and see if there was an effect. And one of the ways they not have an effect is just never look to see if there is one. So I would appreciate
Thank you. Yes, sir.
Good evening, Mr. Chairman, fellow commissioners. My name is Aaron Snyder with Crown Castle. We're a wireless infrastructure provider that works on behalf of all the carriers. I wanted to make a couple of comments tonight on the state of the ordinance. First off, I wanted to say thank you to city staff, John and Jennifer and Mr. Porter. It's very helpful to work with staff that's been very cooperative in having the wireless meetings that we've had, and they've been very helpful in just taking comments and working towards finding a good platform for this ordinance. I did want to take a second just right off the bat to answer Commissioner Zeke's comments about some of the justifications that we submit and some of the deployments and network designs that we have. A lot of the time we look at two aspects, both coverage and capacity. Our RF engineers, what they do is put together basic mapping criteria, and a lot of the time the type of technologies that we look at today, they require a certain decibel level in our tools. And so we look at a certain area, like Mr. Porter had mentioned, a lot of areas today have coverage levels, but what they don't have is that capacity metric. And so as we look towards 4G and LTE and 5G, we have to have minimum threshold levels for those certain types of technologies. So that's where that capacity side comes in. That's where you look at a 2-lane freeway that we need to get to 4 and 6 and 8 lanes. So again, we focus on these minimum levels that we need for these technologies to be able to be deployed. And so that's a basic understanding there. Another thing that I wanted to mention was the technical and feasibility aspect. I know that a big thing that was brought up several times is the 500-foot site plan evaluation. Another thing to consider that wasn't necessarily elaborated on from a staff level is the fact that we have to also pay attention to utility-specific code. We're looking at concrete streetlights and utility poles. In both scenarios, there's utility code from Southern California Edison that owns the streetlights, and then the Joint Pole Association that manages utility poles. When we go out and look at those 500 feet worth of poles in that given area, we have to work with both of those branches in evaluating if we can use those poles. And so the ordinance doesn't necessarily elaborate on that, but again, when we go to evaluate those options in a given area, we have to work within the confines of those regulations before we submit that justification to the city, because that takes precedent in the matter. So just again, another thing to pay attention to. Also, just in the general sense, I did want to talk about the fact that Crown Castle and the carriers in general, we have either FCC licenses or state franchises, and I've been to several meetings to date, and I just wanted to bring up those particular documentations. Serious general interests from a business perspective, and then also from a state and federal regulatory perspective, to keep good business practice in mind. And the reason why I bring that up is I understand some of the residential concerns about us maintaining a good cooperative relationship with the city and submitting applications with the correct requirements in place, specifically the EME issues. But again, we have state and federal oversight as well. And so I just want to assure you all that we have to follow not only state control, but also, city control, but also state and federal oversight in this. Because if we do mess up in any of those things, we have to deal with various bodies as well. So again, we have lots of other things to consider when we deploy these networks.
Okay, thank you, Mr. Snyder. I had her go 4 minutes, so I'll let you go for it. But I think there's a couple of questions up here real quick for you. I know Commissioner Zick has one, and then I have one for you as well.
Sure.
So.
Thank you for the information you presented. My question is based on an understanding that I had or a kind of a paradigm I had about these applications coming from the providers, Sprint, Verizon, T-Mobile, et cetera, and all the requirements associated with those applications, in my mind, fall on them. When I hear you talking about your company, Crown Castle Construction, my first thought would be that you're the company they hire to dig the hole and put in the pole. But it sounds like you have information and a background that almost sounds like you're the provider. So could you help clarify for me the role that you play relative to these other providers? And is your relationship with each of the providers indivisibly arm's length relationships?
I can explain a little bit more about Crown Castle in general. We're an infrastructure provider. We focus more on the fiber optics. Our company is fairly large. We deploy small cell nodes. We also deploy macro sites, and we work with all carriers in general. But again, we're more of the infrastructure side of things. Our company, best way to say it is, again, we have a tendency to not focus so much on specific technologies or carriers as much as, if we're taking Mr. Porter's example, we're talking more along the lines of the freeway and not so much the cars or the on-ramp and off-ramps. So our business model has a tendency to focus on the lanes on the freeway instead. If that's the better way to talk about it.
So if there's a small cell site that is going to be constructed on a pole near my home, it's your company that's going to show up to do the construction, correct?
We work with several of the contractors.
Okay.
We have a large umbrella of general contractors, yes.
And the hardware that gets installed, the actual small cell site, is installed by you or installed by, let's say, Verizon, if they're the provider?
Easy way to explain that is we would be hired by Verizon or Sprint or T-Mobile in that instance, and we have an umbrella of people that work underneath us, and we would be the ones who would be hiring them to do the work.
Who owns the hardware that you've installed, you or Verizon?
It's contract dependent.
So you're a pretty big stakeholder in this.
Frame of reference, we've built 3,000 or 4,000 small cells in Southern California in the last year.
Interesting. Thank you, sir.
Yep.
Quick question. Thank you, Mr. Snyder. So when you guys huddle and you're figuring out strategy on how we're going to roll out this technology, how far out are you looking?
We try our best to gauge demand. There was a comment about trying to think of deploying a master plan within the span of a year to two. And to be honest, I've worked with Crown for 6 years now, and I try not to be a betting man, but I would lose that battle 9 times out of 10 because the way technology changes and demand changes, that's ever constant. Change is always constant in our industry. And so it's very hard to take that at 2 years. 6 months is even a challenge.
So how often do you meet to decide where you're going to put, or so if you have the ability to batch applications under this ordinance, you sit down in a meeting, and how far out are you going to look? You're just going to say, well, let's say for November, we're going to put in a batch for 5 applications here, here, and here, and we don't know what we're going to do in December. Is it that?
No, we would know. I mean, if we're doing a project for Carrier X and it's 50 sites for a city of Costa Mesa, we would know in a calendar year that we would have 25 that would be going on a utility pole and 25 that would be going on a street light. We would have an idea to forecast out a given year based on that project. My concern, generally speaking, with batching applications is some of the language in the code doesn't allow us to make changes to batching the application. For example, if there was an issue with one of the locations, we would like to have some flexibility if, for example, there needed to be a change to one of those applications. We would like to be able to remove that application from the batch. But I believe as it sits right now, the way the language is, we would in essence lose the entire batch. If it was batched in 5, if one was bad, we would lose all 5.
What would change in 60 to 90 days to make you want to pull out a particular facility?
Well, a lot of the time, for example, with Southern California Edison poles, there's a lot of issues with foundations, things like that. The approval process with SCE can take 6 to 9 months. Working with a third party, the control measures are kind of tough to gauge. You can run into issues with power designs. There's a lot of third party control measures that have a tendency to change.
Okay. All right. I think that's it for me. Commissioner Colbert, aren't you glad you got up to speak?
This is fun. I have just one question. You mentioned coverage and capacity, and specifically related to that, you used examples of the highway and also the lanes, which I may ask questions about later to someone else. But as it relates to the limitations, what potential limitations would exist as it relates to capacity, and how do you identify those limitations? For example, would it limit. So signals and 5 bars versus 2 bars, streaming access to phones. Like, what are the limitations that become like restricted by this capacity question?
And I'm not an RF engineer by trade, but the easiest way to discuss it would have to deal with the propagation metrics. And what I say by propagation is how far an individual node would cover from like a given location. 200 feet, 300 feet, 400 feet, 500 feet, is if it's a coverage design, it may in fact cover up to 500 feet. If it's a capacity design, it may cover 200 to 300 feet, but that would all be dependent upon where it would be if it's on 19th and Harbor, or Harbor in the 405 freeway. If there was a need driven based off capacity, you might see it only cover 200 to 300 feet because there's obviously the traffic there with everybody with a cell phone. So if that explains it for you.
Not exactly, but thank you.
Okay. I apologize again, not an engineer by trade.
So one other quick thing. So have you represented Verizon in the past?
Again, we work with a lot of carriers.
Most of them competitors?
Yeah, they would be.
How do you guys firewall any conflicts of competitive conflicts? In other words, you have information you know about one character X or carrier X who's competing with carrier Y, and they're both your clients. How do you firewall that?
I try to focus in my conversation with staff, and I try to focus on these things more about process. And just in particular, I've chatted with staff on several occasions. I try to look at this more from a process standpoint, because regardless, we'll be in here doing work, looking at 10, 20, 30, 40 applications, regardless of the carrier. And Costa Mesa is in an extremely unique position. Near a freeway, near the beaches, 8 to 10 months out of the year, your population skyrockets.
Right. Okay, I got it. Costa Mesa seems to be in a unique position on a lot of issues these days, so that's fine. Okay, thank you very much. Next person.
Thank you.
Hi, guys. Allison Burchett, representing Costa Mesa Advocacy Group. And before I start, everything I'll be presenting tonight has either been provided by my attorney or has been validated by our attorney, so I'm not presenting anything that's outside of the scope of the city's jurisdiction. I'm going to start with an easy one. And Scott, you kind of set us up for this easy one, and thank you for that, kind of leading us into it, but we're talking about how you can't be discriminatory between distance and poles. And in fact, by naming that they are by carrier, that in and of itself is discriminatory. So I just want to point out that the city lacks authority to require spacing based on carrier. The justification needs to be reducing visual clutter, and visual clutter is not impacted by carrier, so it needs to be a blanket visual clutter based on poles regardless of carrier, because they don't look any different because they're Sprint or T-Mobile. And that's from the FCC's third report order 18-33 paragraph 91. Okay, so that is distance between poles. We are asking for 1,000 feet regardless of carrier, which was your original preference, and there's no reason that I understand that that would have been changed. Visual clutter is visual clutter. So next, I want to talk about the tiered zones, and that they are in and of themselves ineffective. And so I know that there's an interest to not have the residential areas first pass. So the only way to really make sure that the providers are doing their diligence and looking outside of the residential zone is to expand that 500-foot radius upon which they have to look outside. So say they want to go, on whatever street, they need to look farther than a 500-foot radius, because if they're just looking in a 500-foot radius, de facto, they're also still going to be in a residential zone. So we're back to where we are. So that needs to be expanded. As well, I think doubling down on the burden of proof. I mean, when they're saying material inhibition, there might be some materials that would do that. I want to also point out on the notification, ADA, so I am electromagnetically sensitive. I would be covered under the ADA, and I would have a right to appeal, so you might want to lengthen that time and make sure that you do a proper notification process. As well, that fee, the $1,200, is exorbitant and it's totally discriminatory. And what about lower income families? Are they not going to be able to appeal? As well, that's something that's set by the city, so you guys can decide what that fee is. And then RF testing, it's good, and that's on handwritten page 10, but it needs to also add in the field. So it sounds like it might just be a math equation right now. It needs to actually have a field test element, right? Because your calculations could be wrong, and you need to know what the actual is. And then also in the tiered residential zones, there's nowhere where it's listed schools. And that's a major concern for the residents and, our group in particular. There's no, negative preference on school zones. So that needs to be incorporated as well. So my recommendation tonight is to amend the design guidelines to have tighter tiers and to have a fall zone. So if it does go within a residential or school zone, that they've had to prove that they have to be there through some kind of material proof, through their material inhibition. And then also there's 100 feet or 300 feet or 500 feet, like most cities, San Diego being one of them, very similar in construct to Costa Mesa. Thanks.
Thank you. Next person. Yes.
You just mentioned San Diego. So San Diego is a smart city pilot program right now, and they, in their cell phone ordinance, it's 1,000 feet. I hope you're looking at other cities and don't just blindly follow our staff. There's other cities that have much stronger ordinances than this. And Mr. Derrico, you mentioned somehow Costa Mesa always ends up in the middle of all this stuff. Well, guess why that is? Look at your former council. So Friday night, China Syndrome was on. Some of you might have seen that a long time ago. It has Jane Fonda and Michael Douglas when he was young and good looking. And it's about how our power plant, nuclear power plant, everything was so safe and everything's perfect and they crammed it down our throat, and now look what we have down the road here at San Onofre. All these things that they keep telling us are so safe. I mentioned the technology they're basing on this is 24 years old, 24 years old with all this stuff that is going on right now. Why in God's name are we relying on that kind of technology? And if we have to be the first, then let's just do it and do it right. Instead of being clueless and corrupt, let's be smart like San Diego. And another thing, it's very interesting that you mentioned that, Mr. Derrico, how we get in the middle of everything because along with the sober living nightmare that was created, right along with that is Mobilite's cell phone. Their office is in the Back Bay, and guess what just happened to Mobilite's cell phone office? It became Southern California Recovery. It's very interesting to me how Mr. Gary Jabara and Villa Real Estate and Mobilite's cell phone are all involved in cell phone towers and sober living, and these are two things that I think are wrecking the city. People say don't combine them, but it's very interesting that the players are the same people. Thank you.
Thank you. Yes, sir.
My name is Ted Flitner. I'm a 20-year Costa Mesa resident. I'm 20 years as an engineer, and I work in IT, I work in computer technology, computer hardware. Just back from Consumer Electronics Show in Vegas. I'm not someone who is tech adverse. I got my cell phone right here. But I also am somebody who understands the technology. I understand the health implications of it. I understand that 5G is not the same as 4G. It's nothing like it in terms of the frequency. We're talking about 30 to 300 gigahertz. It's nothing like 4G technology, LTE. So and the bandwidth, that's, the frequency bands that are being discussed and available for 5G are nothing like what we have with 3G and 4G technology. So, going back to those statements, the old 1996 health codes and kind of what was from the FCC as allowed, it's nothing like what we're going to have in the future. So we need to really consider that. And again, I want to echo some of the same concerns. I want to see bigger distances, 1,000 feet. We have plenty of other cities, growing cities, a growing number of cities in California, in Orange County, that have bigger setbacks, and I want to see the same thing in Costa Mesa. I'm a resident, I'm a tech guy. I'm not, against technology. I want to have safe use of technology. Thank you.
Thank you. Anyone else wish to speak to this item? Okay, we'll close the public comment portion of the public hearing. Commissioners, do you have any additional questions of staff while the public hearing is open that you want to get on the record? Commissioner Colbert? No? Yes? Okay, yes, go ahead.
One of the citizen comments related to the appeal process was mentioned, and I just wanted to get clarification on that. For the appeal process currently, related to any case, what is the cost for that?
It's a tiered cost system for all appeals. If the appeal is made by someone who is outside of the 500-foot mailing radius, the cost is higher. If it's within the 500-foot mail radius, it's lower. It's on the order of $3,000 for anyone who's outside of the 500-foot radius, and about $1,200 for anyone who's inside the radius.
And just for clarification, if an item is brought before a commissioner and a commissioner decides that we can pull that at no cost, is that correct?
Not for wireless facilities, no, because of the shot clock timelines.
So even we're restricted with that?
That's correct.
So we would have to, okay.
That's correct. The council can set a different fee structure if they like, but those are the appeal fees that are in place now citywide.
Okay. Thank you.
Anyone else?
Over here.
Oh, I'm sorry. I owe you like flowers or something. I was like, Commissioner Torje, please.
Yeah, I just had one question, and I wanted to ask this before, and I really appreciate Monica bringing it up. The macro cells included in this ordinance, can you give the reasoning why they're included in the ordinance?
Yes, so macro cells are already included in this section of the code. This section of the code has to deal with all wireless installations within public right-of-way. So that includes macro cells, small cells, and the process that is outlined now, which is a minor conditional use permit that is reviewed by the zoning administrator, ultimately appealable to the planning commission, is the same process that the city staff essentially copied the same process and just carried it over in this ordinance. That those requirements are already in the ordinance.
Okay. I drove by the one on 20th and Tustin today just to review, and it's pretty ugly. So what you're saying is that nothing has changed between what was determined before about macro cells and what is currently there. It's just included in the ordinance.
The process is exactly the same. Minor conditional use permit reviewed by the zoning administrator, appealable to planning commission, exactly the same. The only thing that's different is that now all of the application information and the standard conditions and all the requirements that we've outlined in this ordinance will now apply to any application for macro cells in public right-of-way as well.
Okay.
That did not exist before.
Okay, thank you.
Any other questions? Commissioner Russell and then Commissioner Zick. And then you have some too? All right.
Just a quick question for staff. Mr. Humphreys was talking about people knowing when a pole is going to be having a cell sited on there. Is there any way that we could simply put a sign on that particular pole to let people know to not?
Yes, that's actually already a requirement in the proposed ordinance. I just didn't highlight it in my presentation.
Okay.
But the noticing requirements are the 500-foot mailing radius and to post a notice on the pole itself.
All right, thanks.
Okay, Commissioner Zick and then Commissioner Perkins.
Thank you. Let me piggyback on that last question. So your answer about tagging the pole was included in the phraseology of the 500-foot radius noticing requirement, which is for discretionary approvals. So for the ministerial approval, is the pole still tagged or no?
The noticing requirements apply only to discretionary review.
So the tagging of the pole is only associated with the discretionary approvals?
Correct.
Okay, so back to my original concern, echoed by, okay, I think I've got the answer to that. One of the members of the public mentioned something that I've not heard before, I'm not familiar with, on-strand cable company facilities. Does this ring a bell with you? Are these wireless emanating similar to, can you speak to what those are and how we have them covered, if at all, in our ordinances?
So we have not had any applications for strand-mounted facilities. We understand that some wireless carriers do propose them. They're essentially facilities that are mounted to cables strung in between poles in a very general sense. They have not been something that has been proposed in Costa Mesa or even in surrounding cities often in the past, but we did cover it in the sense of when we talk about preferred support structures, strand-mounted facilities is our least preferred, but any facility that's located in public right-of-way would be required to go through this process, including strand-mounted, unless there's some facility that's outside of the right-of-way that I'm not familiar with, but anything in the public right-of-way goes through this process.
So if there's a string of utility poles that are along the backside of my property and adjacent residential properties, those are not on public right-of-way, correct?
Correct.
So strand-mounted equipment could occur there without the city having any jurisdiction whatsoever?
The city would have jurisdiction because at that point it would be on private property and it would be reviewed under our zoning ordinance.
Okay. Could you speak also to this idea that I'm also unfamiliar with, ADA protection for people sensitive to RF emanations?
So as you're aware, federal law requires cities and members of the public to comply with the Americans with Disabilities Act. We need to make sure that people with disabilities are protected. And what is being requested is that the city, if I understand what is being requested, is that they're requesting that the city would take into account a member of the public who claims to have particular sensitivity to radio frequency emissions. And our recommendation would be that we not go down that path because, number one, our ordinance already says they need to ensure that they comply with the ADA. So if they're violating the law, then if there's a member of the public that has RF sensitivity and they want to claim that that is protected by the ADA, and I will say that there is one, I'm blanking on the name, but at any rate, there is an FCC, sorry, not FCC. There is some justification for the argument that these people are protected by the ADA. And so if that person would have the right to sue the telephone corporation and say, you are violating my rights. So because federal law prohibits a city from regulating based on RF emissions, our recommendation is that we not get into that fight. Simply, we say if it complies with federal RF emission standards, we're done.
So from that, what you're saying is that if a small cell site installation is going on next to a person's property who has this condition protected under the ADA, presumably.
Arguably.
Their recourse would be directly to the carrier.
Correct.
Okay. I understand that answer. So I was a little bit, I'll use the word confused, maybe concerned, about the arrangement that seems to exist or will exist between Crown Castle and the various carriers, even to the extent that certain small cell sites would be owned by, potentially, based on the nature of the contract, as I heard it explained, owned by Crown Castle and not by the individual carrier. And so then as we are dealing with the distance between adjacent sites, how do we know? So if Crown Castle owns a site at one pole, and just down the street there's another pole, and Crown Castle's putting that thing in too, and oh, by the way, they're also going to own that hardware, and that pole is less than 500 feet away, yet it's for a different carrier, but it's actually owned by Crown Castle. How are we managing that issue? That seems, I'm concerned about that.
Usually, we know who the end applicant is going to be. So Crown Castle will say, we are deploying on behalf of Verizon Wireless. Then we can look at Verizon's network and say, hey, you know, you've got another facility 20 feet away. We think that maybe that's overkill.
Okay, thank you. Oh, wait. Yes, thank you very much.
Okay, Commissioner Perkins.
Thank you. I know one comment from the public was asking about if the standard condition of approval for post-installation certification was requiring on-site RF testing. And on hand-numbered page 19, and staff can confirm this with me, it says such documentation shall also include a report from a licensed electrical engineer confirming that on-site RF testing was completed. So does that maybe address the comment from the
It's
public?
already included in the ordinance.
Thank you. So that handles that one. For the tree, again, responding to a comment from the member of the public, if the installation, this is again hand-numbered page 23, if a installer of this was to damage a tree, it reads like the permittee shall replace any landscape features damaged or displaced by the construction. So I'm not completely familiar with Chapter 5 of Title 15, couldn't read the whole thing up here. Would they have to replace that tree? Or are there, is there concerns about that being able to be replaced with other elements? Or what's the process, I guess, on that, I should ask?
So the process that's outlined in Chapter 5, Title 15 is that an application is submitted for tree removal. Usually what we're talking about, because the city is very particular as to when it allows tree removal. If you've ever watched a meeting of our Parks Committee, you know that they take very seriously tree removal proposals. It would go through that committee for review. A staff report is provided by Public Services staff, including the city's arborist, and an evaluation as to the health of the tree and whether or not it was necessary to take it out. I would imagine that this provision will be rarely used and is really more of a protection for the city and has to do with if there was some sort of unanticipated damage during construction. The section in the ordinance is really intended to be procedural in nature and describe the process that any such request would go through. But if you look at handwritten page 38, these are the design guidelines that were adopted by the City Council in October. And council specifically asked for staff to add the language that's at the end of this section, trees and landscaping, subsection D. And it says, small wireless facilities and other infrastructure deployment shall not cause the removal of city-installed landscaping except to the minimum extent necessary to allow the pole and related infrastructure, and all other landscaping shall not be replaced with concrete. They were very specific at that time with really discouraging the removal of landscaping in the public right-of-way. We intend to take that seriously. Thank you.
Thank you. Two other quick questions, and actually the design guidelines are where these questions now shift to. We've heard a lot of discussion about the residential setbacks and the setbacks between, distance setbacks between installations of the same provider. Am I correct in reading that both of those distances are encoded in the design guidelines and not in our ordinance tonight?
That is correct. Both of those distances are within the design guidelines approved by City Council in October. They're not the subject of tonight's ordinance.
And so if we or members of the public were to want to see changes to those distances, that would be a matter for another discussion.
This ordinance will go before the city council after the planning commission. The city council would need to direct staff to modify the design guidelines since they approved them.
Okay. Thank you. That is all.
Okay, just a couple more for me. Handwritten page 26 of the draft ordinance. Top of the page, neither the permitting nor any person authorized to act on permittee's behalf shall in any written or oral statement intentionally provide material factual information that is incorrect or misleading or intentionally omit any material information necessary, blah, 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 blah. What's our remedy if they don't do that?
Well, if we could deem their application incomplete, you needed to provide additional information, or if they ended up later on in the process, as we learn additional information, we could say, hey, your application is incomplete because you left out this information or you included information that was false.
So what if the city made an approval of an application based on false information? What's the remedy there? Can we fine them?
So if it violates the conditions of approval, then we could cite the condition with approval, and I'm being pointed out that, so the question is whether we have conditions of approval that say that, and it looks like one of the standard conditions is, is that a standard condition?
Right, it looks like what you're reading from is a standard condition that would be imposed on all applications. So I think what we're talking about is sort of post-installation, what are the remedies if a carrier, for example, provides misleading information and we rely on that misleading information.
Right.
My apologies for misunderstanding. So because that's a standard condition, then we could say, well, you're violating your conditions of approval, we could potentially revoke your permit.
Could we fine them?
For violation of the municipal code, potentially.
For using fraudulent information to get a permit?
I would imagine the most likely remedy would be we issue notice to correct and whatever needs correction, or potentially they would lose. There are any number of ways that we could enforce. Fines are potentially one of them. Most likely the biggest threat would be revocation of the permit.
I'm curious about that. I'm curious about having a remedy in which the city can exact a financial toll on an applicant that provides fraudulent information that leads to the approval of an application. I would be interested between now and the city council if this ordinance gets moved on tonight to have that, have them ask that question too, see if it's possible. Follow up on a question Ms. Burchett had regarding discrimination. What would be the effect of having just a distance requirement between poles without reference to carrier?
So if our code did that, then there's the potential that that would violate federal law. Because if you say nobody can install within 100 feet of this facility, and that is the only place that a wireless facility can go from a different provider, then we're essentially saying you cannot provide service in that area. Now, if the smaller the distance, the greater the likelihood that it's not a problem. You're not effectively prohibiting anything. So that's the potential risk.
Okay.
And I should say that the more restrictive that we are in our regulations, that if we limit what qualifies as ministerial, then therefore more things would necessarily become discretionary. And so that's a burden on staff, and you want to figure out the appropriate balance between what do we want to encourage, so then providers do what we want them to do, and then hopefully the discretionary things are the things that we don't want them to do, because that's a more obstreperous process, and then we want to encourage them to do what we like.
Okay. Okay, thank you. Anyone else? I'm going to close the public hearing and ask the commission if they have comments or wish to make a motion on the item. Commissioner Zick.
I'm going to make a motion, and I have some comments to go along with it. I think I'll start with some of the comments. I think the current state of this ordinance is significantly improved over the first versions that we saw. I also think that there's almost no way to craft this ordinance in such a way as to satisfy what seems to be the predominant concern from residents relative to the RF emanations, given the limitations we have based on the FCC. And I don't like that, but there are a lot of things out there that I don't like and can't seem to change. I also think that since what we're doing here is recommending to council to give a first and second readings to this ordinance, there is plenty of time for there to be more input and more changes to this ordinance based on those inputs, as well as based on the interests that the council members may bring to this. I suspect if we kept working on this for another 2 months, while some of the nuances might be addressed and changed, the predominant concern by residents would probably not be addressed. And I think it's time for council to take what we've done, which I think collectively is a good body of work. Given that, then, I'm going to recommend that the Planning Commission adopt a resolution to find that the project is exempt from the provisions of the California Environmental Quality Act, CEQA, under CEQA Guidelines Section 15061B3, General Rule Exemption, and recommend that the City Council give first reading to an ordinance approving Code Amendment CO 19-04, amending Title 19 and Title 13 of the Costa Mesa Municipal Code relating to wireless telecommunication facilities and related infrastructure within the public right-of-way, with the addition of 2 words into the notice section, which is on handwritten page 53. And the 2 words that I am including in my motion to approve are the words "or ministerial." So the first sentence of the notices paragraph would read, based on my motion, notices of the upcoming director, zoning administrator, or city manager discretionary or ministerial decisions shall be provided to the applicant and provided as described in subsection D1(2), et cetera, et cetera. And this is relating to the 500-foot notice requirement that members of the public would receive. I think it is critical that members of the public who have poles outside their house that get targeted for this know about it. That's my motion. Thank you.
Is there a second? Yes, Commissioner Tourget seconds. Before we get into that, if I could ask a quick question of legal counsel or staff, are not notices of the upcoming director, zoning administrator, or city manager in themselves ministerial?
They're all interchangeable.
So we'll look through the ordinance to make sure that we're changing the concept in all the right places, but the ministerial decisions are made by the director. So we think this section covers it, but we'll be sure to review it and insert that language in.
Because I support what he wants to do. I think the more noticing, the better. So I agree with that. I was worried we're adding a word that basically describes the three words you put in that are there before ministerial, so.
So if it's a friendly amendment, then staff will, if there are any other conforming changes, then we would make those same changes to affect your purpose.
I should have smiled. It was very friendly.
Okay. Any other comments on the motion? Commissioner Perkins?
Yes, I have one comment that I would like to propose the addition of clarifying the section on appeal timeline to include the text from section 2-305 of our municipal code on the, if the final day falls on a weekend or holiday, they have until the next business day to turn in that appeal to make it just perfectly crystal clear.
Yeah, that was a good idea. I accept that.
How about the second? You good with that?
I'm good with that. And I also want to second what Commissioner Zick said, in that I don't know if we're ever going to get to a place where we can comment on or make decisions based on the health concerns. And so I'm looking forward to council's reading of this as well.
Okay. Anyone else? Vice Chair?
Yes. I almost feel compelled to at least say something about this, not because I've been relatively quiet all night, but because I agree with my colleagues. I don't know how we can make this a perfect ordinance, and we can spend an inordinate amount of time of doing it and still not get the results that we want. But I think what staff has presented, and we've been given a fair amount of direction from the council on this already, I believe is as good as we're going to get here. So I will be supporting the motion.
Okay, thank you. So, I feel like we're all kind of bound from head to toe in rope. We're like really tight. We're just hopping around trying to get something done that somebody else really doesn't want us to get done ultimately. And we're doing it rather awkwardly. And, it's interesting to me, this whole issue isn't really about the science of emissions, because all my reading and that I've done, and I've done a lot of it, science really isn't settled yet. I mean, there's some indications one way and there's some indications the other. So the science really isn't settled, but this is purely a political issue. I guarantee it. There are big interests who want to roll out this technology nationwide, and among them are the federal government and state governments and telecommunication providers who want to roll out this technology as quickly as possible. To wit, you have an FCC that basically says, we don't, there may be data about 4G and there may be data about 5G, and we could consider that and maybe modify what local jurisdictions can look at as to what is acceptable, but we'll just stick with the 1996 standards, which they just recently did. So the bottom line is we are roped and tied and very limited in what we can do, and the best thing we can do is put in place a regulatory regime within the constructs of the federal law that creates a fairly rigorous set of hoops that these folks have to jump through to get their permits. And I think this does it about as best as it can without setting ourselves up for millions and millions of dollars of more legal action that we have to defend, in addition to sober living, in addition to homelessness. We still have police officers and firefighters we have to pay. We still have infrastructure issues we have to take care of. Costa Mesa doesn't have the benefit of an endless pot of money where we can go and run and chase all these legal matters. And this just happens to be one where the federal government is dictating what we can and can't consider, and it's very limited. So to the extent that we can regulate it, we're, I think, doing it in a way that's rigorous enough where the public will have a reasonable amount of opportunity to weigh in. And so I'm going to support the motion too. Not happy about it necessarily, but I've been around long enough to know that that's the political reality. And again, this is a political reality. I will then call for the question.
That motion carried 7-0.
Okay, so that will be going on to the city council for their consideration, and I would like to take a 10-minute break. We'll come back at 8:20, roughly 10 minutes. Thank you. All right, we're ready to go back on. Thank you. We're back in session, and we're at public hearing item number 2. Julie, please.
Public hearing item number 2, zoning application 19-83 for a minor conditional use permit to deviate from shared parking requirements for an individual and group counseling use located at 2790 Harbor Boulevard, Suites 307, 309, and 310. This is a call to report any ex parte communications.
Commissioners, any communications to report? Commissioner Perkins.
There we go. The property that this hearing is on is within 1,000 feet of my employer's property. I do not think I have a conflict of interest, but I would defer to Mr. Preziosi.
Mr. Preziosi, do you have any advice for Commissioner Perkins on his participation?
I concur that the mere presence of his employer's property, his employer being a public entity in the form of the junior college district, so the junior college district, does not create a conflict of interest. It has no material financial effect upon Mr. Perkins directly or indirectly. The city has no zoning authority over the community college district, and furthermore, even if it did, he would likely be exempt from the under the FPPC regulation 18703E7, which is the public generally exception.
Okay. So Commissioner Perkins, it looks like you get to play ball. Very good. Anyone else? Okay. Mr. Arias, the floor is yours.
All right. Good evening, Chair, Planning Commissioners. Justin Arias, Assistant Planner. The item before you tonight is zoning application 1983, which is a request for a minor conditional use permit to deviate from shared parking requirements for an individual and group counseling use located in multiple suites of an existing commercial building. The project site is located on the southeast corner of Adams Avenue and Harbor Boulevard. The site has 3 street frontages along Harbor Boulevard, Adams Avenue, and Peterson Place, and has 2 points of ingress and egress, one along Adams Avenue and one on Peterson Place. The property also shares vehicular access with the property located to the south, and there is a recorded agreement which ensures that there will be vehicular access between the properties. This is not a shared parking agreement, however, which would require approval of a conditional use permit to be formally recognized by the city. The subject property is zoned C1 local business with a general plan land use designation of general commercial. The surrounding properties are also commercially zoned with the exception of the residential properties located to the east across Peterson Place. Here's a proposed site plan for the project site. As referenced in the supplemental memo, the project site has 50 existing parking spaces. However, 65 spaces are proposed to be provided after restriping of the parking lot. In addition, conditions of approval ensure that the proposed parking lot improvements bring the site more into conformance with current development standards. Here are some site photos of the existing development. The site is currently developed with an approximately 22,000 square foot, 3-story building. Existing businesses within the multi-tenant building include various commercial, office, and retail uses. And it should also be noted that the previous use within the subject suites was a similar group counseling use approved under a previous zoning code interpretation. The use would occupy 3 suites within the existing building. 2 of the suites would be dedicated to administrative services, and 1 suite would be dedicated to counseling services. There would be 2 rooms located, both of them located within Suite 309 that would be designated as group counseling areas. The remaining offices would be used for administrative services and individual counseling sessions. As described in the applicant letter, the use would involve individual and group counseling as well as individual case management. The majority of the operation at this location would be comprised of administrative services. The proposed administrative hours of operation are weekdays from 8:30 a.m. to 4:30 p.m., and programming hours of operation, which would be individual and group counseling, are proposed weekdays with the exception of Tuesdays from 10 a.m. to 1 p.m.
As proposed, up to 2 administrative corporate staff would be on site, and all counseling participants, both individual and group, would be brought to and from the site by passenger vans. With a maximum of 35 persons, inclusive of clients and employees, would be located within the facility at any one time. This would include no more than 10 employees and no more than 25 clients. In addition, the use does not allow walk-up clients at their location and does not allow clients to drive their personal vehicles to the site. As proposed, the use would operate without utilizing more than 4 parking spaces, 2 for administrative staff and 2 for the passenger vans. Parking impacts are not anticipated from the proposed use. During operation of the administrative staff, as mentioned, only 2 parking spaces would be utilized by that staff. And then during programming hours of operation, only 2 additional parking spaces would be needed for a total of 4. Furthermore, conditions of approval are proposed which ensure that the use operates as proposed. Some of the included conditions of approval are related to the proposed hours of operation of the use, the areas permitted for group counseling, the maximum number of shuttle vans permitted to be utilized by this use, the requirement that all participants during programming hours be brought to and from the site via shuttle vans. In addition, staff also included conditions related to outdoor smoking area if it were to be proposed, the requirement to address any parking problems should they arise, and the requirement to restripe the parking lot in accordance with the site plan. With that, staff recommends that the Planning Commission adopt a resolution to find the project categorically exempt from the provisions of CEQA under Section 15301 for existing facilities and approve zoning application 1983 subject to conditions of approval. That concludes my presentation. I'm available to answer questions.
Thank you, Mr. Arias. Commissioners, any comments of staff? Questions, rather. Commissioner Zick?
Just a couple. Thank you for that staff report, Justin. What's being requested is a minor conditional use permit. If you would remind me the difference between the minor conditional use permit and the conditional use permit. Does the minor conditional use permit not run with the land?
The minor conditional use permit does run with the land, and I apologize, I meant to mention this earlier. Minor conditional use permits are typically reviewed by our zoning administrator, but for this specific application, the zoning administrator has referred this to the Planning Commission for their review.
So they run with the land as well?
Correct.
Okay. Are there any other MCUPs or CUPs for this property?
There are. I know there is at least one MCUP for the dance studio that is existing. I would have to do additional research. There might be some other entitlements on the property.
Maybe that's something you could come back to. And then my other question, I'm confused about this, and I'm looking at the staff report, page 3, where it refers on the one hand to 2 administrative staff, and in your presentation you talked about there being parking for 2 administrative staff. But then it also talks about 10 employees. So I'm confused about those 2 different numbers, particularly as it relates to the parking.
Yes, so the additional 8 employees would be the individual counselors who would be doing the group counseling or individual counseling that would also be brought to and from the site via the vans. Got it.
Okay. So in total, there's 10 employees, but the parking requirement for all of those 10 employees is really 4. 2
Correct.
for admin, 2 for vans.
Correct.
Got it. Thank you very much.
Commissioner Tourget?
That was my question.
Okay, Commissioner Perkins?
Yes, I just had one thing. I was looking at the hours of operation we're conditioning for its condition of approval number 2 on handwritten page 6. And I was just wondering, so 8:30 a.m. to 4:30 p.m. are the hours of operation, and then group counseling hours seem very restricted. Mondays, 10 a.m. to 1 p.m., and Wednesday through Friday, 10 a.m. through 1 p.m. Is that, just want to understand, is that something that our staff has recommended? Is that what the applicant has recommended? Where did those numbers come from?
All of the proposed hours of operation, both the admin staff and the programming hours, are proposed by the applicant.
Okay, thank you. And then I think in condition of approval 5, there's a minor typo at the end of the second line. I think is should be are on there. So I don't know if that needs any major change, but during programming hours, a maximum of 35 people are allowed at the facility, I think would be more correct. Minor typo. And that's all I have. Thank you.
Okay. Commissioner Colbert.
Just one question. I noticed that you called out smoking within the presentation, within the staff report, and also within the conditions of approval. Is there something particularly important about smoking on this property, or that it would be prohibited, or why is this called out?
So typically with these type of uses, there would be intermittent breaks. Sometimes they do allow the clients of counseling to take smoking breaks. This is a requirement to ensure that that activity, if it were to occur, doesn't infringe on any adjacent properties.
Okay. And particularly related to the programming of this space with the van access, I was looking at the parking plan, I guess, or site plan for the new parking layout. And I think what concerns me is that you will have a number of drop-offs per day, particularly, and also pickups. And it seems like it's a busy plaza, given the uses, salon, barbershops, and other retail uses that will create traffic. But my concern is that you will have a 12-passenger van throughout the day that will be dropping individuals off and picking individuals up that may create traffic impacts, potentially. I'm not sure. Did the applicant discuss that, or are you aware of that? Can you speak to that?
I believe the applicant could expand a little more in detail on specific questions you might have.
Okay. That's all for now.
Okay. I will open the public hearing and ask the applicant to come forward if they're here. If you have a presentation or if there's any questions. Yes, sir. Have you read the staff report and the conditions of approval, and do you agree with the conditions of approval?
Yes and yes.
Okay. Anything you'd like to offer?
Sure. Well, my name's Stephen Carmel, and I'm the founder and CEO of California Prime. So I just want to thank you all for your time. And Justin, thank you for your presentation. So if you have any questions for me, I'm happy to answer.
Commissioner Colbert.
The question related to the parking and programming of the van, could you respond to that?
Sure. As we had mentioned, the specific programming times, the 10 to 1, we can expect them to be dropped off and picked up. So I wouldn't expect like a lot of commotion or traffic. They'll come out together, and they'll come there together and leave together all in one motion. In addition, I have my office manager with me, so if you have any specific questions related to management as well.
Yeah, I think that would be helpful because I don't understand the efficiency factor of this and how it could potentially create problems. So I'm just trying to understand, is there a better opportunity for there to be a designated drop-off and loading zone? And I'm not sure if that would be a staff-related question or if that was something that could be worked out.
I could probably answer. I'm just, as far as the property itself, usually we'll just have the van drop off, so like we mentioned, 10 o'clock. Usually around 9:50, they'll drop the patients off or clients off, and at 1 o'clock, around 1:10, they'll be picking them up. So it's usually they'll come there together and leave together. I don't really know how else to explain that.
Okay, is this a practice that you've done at other facilities, or
Yes.
is this, okay, how did it work there?
I currently, my main location's in Fountain Valley, so it's the same process. Drop off, pick up, and it's pretty streamlined.
Okay.
If you see the way it's run.
Okay.
Okay. Question I have is, your main facilities in Fountain Valley, same kind of operation where patients come to that facility and they either do individual or group counseling there?
That's correct.
So you're wildly successful and you need more space? Is that the...
Actually, we have a different focus. So the Fountain Valley location, we specialize more in substance abuse, and we're actually at this location going to be focusing more on mental health. So like anxiety, depression are kind of our specialty.
And so these patients will be coming to this location from your Fountain Valley location?
Not necessarily. So Justin had alluded to it, that if, in case maybe a client needs to transport themselves, and maybe they're not local where we'd be able to pick them up, we could have them park there because we have plenty of parking and transport them over to the facility in that circumstance. But majority of them will actually just pick up from a location and transport to the facility. And typically not from the Fountain Valley. They'll, usually it'll be from from their residence.
Okay. Okay, any other questions of the applicant?
Yes, sir.
Commissioner Zick.
So I had a similar question relating to that, and I think you partially answered it, but raised a new question in my mind. So are you located here in Costa Mesa with this facility because this is where the clients are located? You mentioned you'd be picking them up at houses. Are the houses here in Costa Mesa? Is that why this location works for your business?
No, sir. The reason it works for my business, it's actually has the current and previous tenants had the same operation and it was already up and running, and it was kind of more of a turnkey type situation as opposed to starting from scratch. So that's the main reason. As far as where the tenants reside, I'd say probably more in like the Santa Ana, Fountain Valley area. We do not have any in the Costa Mesa area. Again, it's just for convenience that we've really kind of, and my friend is the owner of the other company. So that's kind of how I got the opportunity.
Okay, thank you.
Okay. Commissioner Perkins?
I guess, again, my question comes on the hours of operation. As I understand conditions of approval, you're going to be restricted to operating group counseling sessions in those 10 a.m. to 1 p.m. hours. Is that acceptable? Because I think if that ever wants to get changed, I think you have to come back to us, if I understand things correctly. So it just seems like the 10 a.m. to 1 p.m. seems like a very narrow time window.
I appreciate you bringing that up. I mean, that ideally is kind of where we wanted to, start. If we wanted to be more flexible, that is a good point. But we do not have that plan at this current moment. So if it would be, I don't know if that's something that's appropriate to bring up now. It's not in our foresight at this very moment as far as changing the hours or having flexibility on hours. But if it is, I'm happy to chat with you guys or Justin about that.
I guess I can ask staff, what would the process be, say we approve this tonight, hypothetically, without any modifications? What would be the changes that would need to be taken in place if the business is wildly successful and they want to grow their hours?
So any request to modify a previous approval would be a minor conditional use permit. And then depending on the nature of the requested change, that would ultimately determine who the final review authority would be. So it could, in this case, be the Planning Commission, but it could also be the zoning administrator, depending on the nature of the request.
Okay. Thank you.
Okay, thank you, sir. I will open this for public comment. Anyone wishing to speak to this, please come forward at this time. Yes, sir.
Good evening, Commission. Jay Humphrey, Costa Mesa resident. I've actually don't have some major problems other than the shared parking process. There are already 38 sites, 38 parking spaces low on this from, that exists all there, and I understand that. These guys need 4, and I think they should have, that seems reasonable for what they're saying they do. Like down at the courtyard, that was the same condition that was imposed when the health club went in, and all of a sudden, all the parking was full because people who were supposed to come different ways somehow came a different way than they were supposed to. We've now been told that there is the potential for people not coming from, say, group homes or what have you, but from individual houses, and I just want to make sure that we understand that if those people actually do show up, are they going to make them leave? Are they going to say, nope, you can't, you have to come by van, it's the only way you can get here, period, end of story, no other option. So there are no additional cars going in there, because the truth is that it's real easy to park down at Coco's and walk over there. It's real easy to park at Pier 1 or whatever the import place is and walk over there, because it's only, what, 250 feet. So my concern here is not whether or not they should have a fair share of parking for their activities, and they're actually asking for less than what would be probably the appropriate fair share for theirs. I have no problem with that at all. It may be something down to the fact that you actually connote in the parking lot, these are parking spaces for these folks specifically, so that in fact they don't have the option, well, they still have the option no matter what, but we need to just be aware that those things happen. And we all know what happens when the parking gets out of hand. Things happen 5 years from now, 3 years from now, next week. I'd appreciate it. Just keep an eye on it. Other than that, thank you much. Appreciate it.
Thank you, sir.
So did any
Yes,
of you
ma'am.
go over there and talk to anybody that works in that building? Because they all told me that parking is a nightmare right now. It's a nightmare. So you're going to have these two vans coming, and I don't know if you've gone around to any of the other places where the vans drop off and pick up, but then they park the vans there also. So that's 2 parking spaces gone right there. And then I want someone, before you approve this, I wish you'd postpone it, to watch who gets dropped off there and what goes on when people get dropped off there. And the issue with smoking, I'm sorry, that was excellent that you brought that up, because where in the circle of that building are they going to go outside and smoke? It won't be 1 or 2. When you have a group of sober living people or mental health issues like this, they're all going to be smoking and vaping, and they all go outside together, and it's a nightmare. And where are they going to be showing up? Along Harbor, along Adams, or inside the square of that building? I mean, if you talk to the massage parlor people that are on the first floor, nobody wants this group of people outside smoking in front of their businesses. This is a bad fit for this building. Plus the fact they're saying they're not medical professionals, there's no medical anything going on there. It says it in your determination thing on page 14. So, does that mean there's not going to be any drug testing there? Does that mean there's not going to be any drugs administered there? I'm not buying this. I'm sorry. It sounds just like Solid Landings on 19th Street. Go watch what goes on there. The staff is going to be parking all over the place. There's going to be lab technicians coming in and out. There's going to be other people there besides what they're saying, because this has happened at every single sober living facility in the city of Costa Mesa. They don't tell you the truth about who's going to be parking where and actually how much staff is coming. There's going to be people coming and going that aren't actually hired by the company. They outsource lab technicians and blah, blah, blah. Go over and watch.
Thank you. Anyone else wish to speak to this item? Okay, sir, if I could have you come back up one more time, I may have a couple of questions for you, at least I do. Any testing that's going to be going on in the business with respect to substance abuse testing, anything in the building, in your operation?
Good question. So we are an abstinence-based program, so we will do what's called basic 12-panel testing, which is just the cup. And that can happen, that's in the bathroom on our property, or it would be in our suite, in the bathroom, not in like the public hallway bathroom.
Okay, and how do you mandate, because I see in the conditions of approval number 5, all participants during programming hours shall be brought to and from the site in shuttle vans. How do you assure that happens? Do you do a head count? How do you make sure they all get back on the van? What's that process look like?
Great question. So, this is going to be more of a smaller operation, and we typically, program manager would have a checklist on everyone who comes in and who goes out. So,
Of the van or the facility?
the van to come into programming and to leave. So the person that would be driving, they do a head count and they have a checklist. Usually between 5 and 10 people at most, so it's not anything crazy for them to keep track of.
Okay. Okay, commissioners, anyone else have questions? Commissioner Torje.
I had a question about the smoking. Is there a requirement, and this is, well, actually, that question's for staff. So you're proposing smoking outside of the building in an undesignated location so far?
No, I'm not. I actually have the landlord for that facility, 2790 there. They have a specific location for that, and I believe it's by the trash can out there. And that's for not just that location, but all locations in that building.
Okay.
Did you want to address that?
Am I allowed to approach?
Is that okay?
Yes, sir.
I kind of miss. My name is Jason Tong. I'm not the landlord, but I represent the landlord, and we've had this similar use since 2017, approved under Zoning Administrator 16-1 under Main State Recovery. So they've already been shuttling, and there is a part of their conditions for use was that they smoked at least 25 feet away from the building. So we have a designated area in the parking lot.
Okay, thank you.
And is that true for all your tenants, not just those receiving counseling?
Correct. We don't allow any tenants to smoke by the building.
Okay.
Because it's of California law.
Okay, thank you. Anyone else? Commissioner Perkins.
I guess I'd like to, again, continue to sort of follow up on the hours of counseling operation. I feel like we want to create conditions of approval that are reasonable and will allow a business to be successful without necessarily having to come back time and time again in front of us. Would you have an idea of if there was, I guess I can sort of think of something like, hey, Monday through Friday, 9:30 to 3:30, or, would that be something amenable to you? Would you just like to stick with this and come back later? I just don't want to have to see you come back again and again if your business is successful on.
I really appreciate that. I'd say that the hours of operations would be, maybe if we were to expand or grow on that, would be in line with hours of counseling operations. So maybe 9 to 12, 1 to 4, if we were to grow. But for now, 10 to 1 is, appropriate considering, we're starting from scratch.
Okay. And that's all I have.
Okay, thank you, sir. Quick question for staff. Commissioner Zick, go ahead.
So I'm looking at staff report, page 4, on the subject of parking, because I'm trying to sort of understand in my mind the extent of the ask on this deviation from shared parking requirements. So as I've understood the presentation, their need for parking is only 4 stalls. And there's some skepticism that's been expressed that says that, well, they're going to need more parking than that because they're going to have other people, other vendors, other whatever people showing up. So that's what's rattling around in my head. On page 4, what I'm understanding you to describe there is that for the amount of square footage of this facility, the required parking would be 31 spaces.
Yes, that's correct. And that's at the parking requirement, processing the office use as a trade and vocational school as determined by the zoning administrator.
Right. So relative to the need of that number of 31 spaces, the shortage at the entire site is, you identified that number. Can you refresh my memory? 50 existing stalls. Was it 80 that were required?
88 would be required, and then also with the restriping, the new supply would be 65.
65,
Yes.
88, so what is that, 23 is the shortfall?
Yes.
Yeah, so that's a lot of stalls, but what they're representing is that they're not going to need many of them. So that's the backdrop to this question I have about other MCUPs or CUPs. So since you're indicating that this facility was previously used for a similar type of operation, did that previous operation not have an MCUP for any deviation of parking?
The approval process was different based on the different interpretation at the time.
Help me understand what that means.
The interpretation of
There was a different code interpretation at the time that the prior use was reviewed. Mr. Curtis can provide additional details.
Mr. Curtis.
Mr. Chairman, back in 2016, staff adopted an interpretation. Staff interprets the code, on almost a daily basis. It's not every single thing in it. It covers every single circumstance possible. So staff made an interpretation back in 2016. It had to do with these types of uses being permitted so long as they signed an agreement that they would meet certain operating parameters. That specific interpretation I disagreed with and rescinded it. We had this discussion, I think, about a year ago at the senior center. The same issue came up with a property on 19th Street. We rescinded that interpretation, and now we're under the interpretation that it's required to have an MCUP and go through technically through the zoning administrator, although because of issues with this type of use, like this evening, we're kicking most of these up to the Planning Commission when they come before us.
Okay, and some of that rings a bell because I recall that other discussion that we'd had. So in that previous process approval, since it wasn't an MCUP, that approval didn't run with the land. And so that's what's requiring now this business, even though it's similar, to now need an MCUP because it's underparked based on our code requirements.
That's correct.
And because it's running with the land, then basically any kind of business that subsequently goes into this space would have the benefit of this deviation of parking requirement.
The same type of use operating under the same parameters would be allowed to come into this space.
Okay. Okay, thank you.
Commissioner Colbert.
I want to kind of follow this. I had a couple of questions, and I think the applicant answered them as relates to the type of use and services that they would be providing, specifically related to like medical requirements. But I think I want to understand from staff how we reached this particular use as defining it as a trade or vocational school versus a medical use. Like, how did we get there? And also, can you speak to what the parking requirements would be if it were a medical use? Would they be lower or higher?
So I can speak to the parking requirements for medical versus trade and vocational schools. The medical parking requirement is 6 spaces per 1,000 square feet. The requirement for trade and vocational schools is actually higher, and it requires 10 spaces per 1,000 square feet.
So the staff did an analysis, and the reasons for determining that it was closer to a trade and vocational school than perhaps a typical sort of medical office where you would have sort of single appointments by appointment only. For example, this is a group counseling scenario where there could be multiple clients at the same time at this facility. So the code did not include anything that was really close to this type of group counseling use, so trade and vocational school was the closest.
I think my follow-up question being that this is becoming more of a common use, is this something that staff is looking to add to the code so that we can have parking requirements that speak to this particular use in the future?
We have a code cleanup that we're trying to make sure that it's a little more clear what this use is most similar to. We haven't discussed the specific parking requirement for this type of use where there's sort of a group gathering scenario, but it is something we're looking into for our next code cleanup.
Okay. My next question is related to staff report page number 4. I believe you indicate that the conditions of approval are mentioned that will kind of capture. Basically, the conditions of approval will be the enforcement mechanism for any parking violations. Is that correct? Okay, and so is the condition of approval that would be the enforcement mechanism, is that condition of approval number 1 for any parking violations at the site?
Yes, it could be 1, and then I would also point out, where's that condition? The one about should parking problems arise, the operator should address them.
Yes.
I would also include that one as well.
Okay. And now I want to understand what the threshold for impact is. Like, how are we defining impact? Is it that the applicant has individuals that are parking on site when they should be meeting at the Fountain Valley location? Is it that the applicant has created a parking violation by vehicles being queued outside of the streets? Like, how are we defining, what defines an impact? And like, how do we then say, how do we kick it up to development services or the director to say, you're in violation of the operational standards?
So typically, usually it starts out as a complaint. We'll receive a complaint that there's something at this particular property or queuing in the street or any of the things that you just mentioned. Among others, code enforcement staff go to the site and investigate, talk with the property owner, talk with the operator, and make their own observations and determine whether there is a violation of the conditions. Any of the items that you just mentioned, we would consider violations of these conditions because it's not operating as described.
Okay, all right. Any other questions? All right, quick question. So we think this more aligns with vocational school. Instead of a medical use, what do so I'm trying to ask the question, do the collection of samples qualify as a medical service?
So typically samples alone, especially when it's something that's sort of a home kit that's done in a restroom, for example, is not considered a medical procedure of any sort.
Okay. Okay, if I could have the applicant come up one more time, a quick question, if you don't mind. I noted in the staff report that the programming hours of operation for individual and group counseling is 10 a.m. to 1 p.m. So when you bring a group of patients over in the van, does that include the people who are going to receive individual counseling, or the individual counseling appointments show up separately?
Good question. So it'll be pretty much all inclusive. We will have the therapist and the counselor as two of the employees, and one may do a group and one would do an individual. So it's a small operation, so it's not like, say like 5 clients in a group, there's 4 and one goes in an individual, and that's how they'll make up for it. They'll do one a day, then they'll alternate. So hopefully, if that made sense.
Is there ever an instance where an individual appointment would come individually?
We don't, so they're usually scheduled ahead of time and on like a weekly basis. So they'll be scheduled, and the staff will be aware of who they're meeting with, and so will the patient as well as far as what time. But somebody couldn't just pop in. We're not that type of operation. I think somebody had alluded to that. That's more of like, a doctor's office, or even a regular, maybe therapist, private practice or something where somebody may pop in. But for us, that's not how we can accommodate.
And so the samples you mentioned is the only type of sample you take. There's no blood taking, no blood samples, no swab samples?
No, sir. Just for toxicology, it's just urine.
Okay. And so is this a requirement of being in your program that they have to stay clean? Is that the issue?
We are an abstinence-based program, and so technically, it's, any narcotic use, they wouldn't be able to participate in our program.
I guess what I'm saying is there's no court mandate that your patients have to be tested periodically. There's no.
No.
Okay, so you do it just.
So I'd say that's more at our substance-based location, Fountain Valley. I'd say we get some that may be in some sort of court trouble or with the trouble with the law that maybe we have to speak with the probation officer. I'd say that's probably going to be very unlikely with the mental health population, and that's what we're looking to do at this location.
Okay, Commissioner Zick.
Is the parking lot at that building assigned to the various tenants, or is it general open? I kind of know the answer, but I wanted to hear it. It's general open parking for every tenant in the building?
General open parking.
Okay, thank you. I'll have a question for staff in a minute.
Chair Harlan.
This is more for staff and possibly the landlord's representative. So I'm looking at handwritten 11, and it looks like a breakdown of the tenants. By my very rough calculations, it looks like there's about 5,000 square feet of vacant tenant space. Is that correct?
I believe so. I don't know the number offhand. It's a legal non-conforming building because it was built in 1965, and the way the developers or the sellers sold it, our parcel just happened to be smaller.
Right. Well, I mean, this is just about parking. So if it's 5,000 square feet of vacant space, and we're using a general commercial ratio of 4 spaces per 1,000, that's roughly 20 spaces that seem to be available at the building right now. I mean, you don't have to answer. I'm just spouting off numbers. More to the point, it seems like there's some capacity. So I just want to know from your experience as the landlord, does it seem like there's capacity?
Yeah, definitely. I actually have an office that overlooks the parking lot, and there's always available parking spaces. Justin had mentioned reciprocal agreement between the different parcels that from 1968, I believe. It actually runs down to the Pier 1, and it calls for indiscriminate parking between all the parcels. So I don't know how the city interprets that, but that's the reality of how the shopping center operates.
Right. Okay. I'll just note that there's a little incongruity here in that it's, the general parking standard is developed based on the zoning of general commercial, but now we're looking at a very particular use which may or may not impact or have more parking requirements. To my mind, it looks like at least there's some capacity here. So I would take that into consideration in evaluating this request.
Yeah, and I just wanted to note that the 4 spaces that they're proposing is less than an office use would be for the 3,000 square feet.
Okay. Commissioner Perkins?
My question was answered by the prior comments. Thank you.
Commissioner Russell?
Yeah, for the applicant, according to the report, you could have up to 25 people at the building at one time, and you've got 3 hours of their either being individually counseled or group. Can you kind of walk me through how long a group counseling appointment would be, how long the individual appointment would be? And if you've got 25 people there, are they all in a program at the same time, or are there some of them out waiting their turn in a waiting room?
That's a good question. So the programming hours are based on our 3 hours total. There's 3 hours of programming. It'll be 10 to 1. But as far as the group sessions, as far as they're scheduled, it'd be an hour and a half each. So total of 3 hours, like a 10-minute break in between. So it'd be like an hour and, I guess, 25 minutes each. And then there'd be a break in between. And then as far as individually, you know, I had mentioned it before that, you know, that'll be pre-scheduled. So maybe that individual may not attend that group because they're in an individual separately. As far as the 25 capacity, I mean, you know, obviously that we'd love to help that many people, and, you know, we'll see how it goes from here, but I haven't really anticipated that size. I don't think we would have 25 people there at once.
How many, in general, what's your expectation of how many people you're going to have there at one time?
As for us, the main thing is we want it to be comfortable. That would be, we don't have enough space for that. So I'd say between 10 and 15 on the high end at one time. You know, I know the gentleman had mentioned earlier, Mr. Perkins, that, you know, if we were to expand things later on, you know, it would be split. It would keep the same. Maybe we do another group batch, like an afternoon or something like that. So, but we'd keep the same capacity for both times, if that makes sense.
Kind of, yeah. I guess I'm just concerned about there being people that are not in group and not in individual, but they're waiting for their bus, or that they're going to be out in the parking lot. Are they going to be, you know, where are they going to be? Do you have a waiting area?
We do, but there's not going to be any like floundering around. It's important for us that it's very structured, my operation, and you know, as I'd mentioned earlier, they get there together, they leave together. In between, they go on a break with a staff member if they were to smoke or something, or if they just get some water. You know, staff members there. Nobody's just floundering around.
So if they were going on a smoke break, you'd have a staff person that went with them down there?
There's always a staff member, yeah. It's just for our sake, we just want to keep a tighter leash on everything.
Yeah, I'm just thinking in terms of, you know, there's residences fairly close, and the other businesses, I think we heard that there may be some concerns on their part, so I want to make sure that we eliminate as much of that as possible.
Yeah, it's important for us to maintain the structure and to keep, everything kind of tight as possible. So I wouldn't anticipate any like floundering around or anything or loitering.
Okay, thank you.
Commissioner Colbert and then Commissioner Zick.
My question is still lingering around the use piece, but that's more related to staff. I think what concerns me is that initially you stated that the primary services that you will be providing at this location were for depression or antidepressant services or some type of counseling related to, but none like you provide at your other location in Fountain Valley. Is that correct?
I had mentioned that we specialize at Fountain Valley in substance abuse, and sometimes it may be, something that goes together depending on the individual.
But what will you be doing at this site?
Mental health.
Mental health.
So, I mentioned specialties. I'd mentioned anxiety and depression are two common specialties for us.
Okay. This is kind of an unrelated, but I want to understand, what is the need for a urine test for mental health? And is this related to the absence and you have to do it on location because you're picking them up and that's the only place you're going to test them, or?
Yeah, I'd say that for us, we are an abstinence-based program, so it's not, and some individuals may, have previously had, maybe a substance abuse issue or something like that. So it's really case by case. But for us, it's important to maintain, that nobody's abusing anything, whether it's even their own medication they're taking or anything like that. So there's ways to even track their own medication, and that it shows that they're being truthful, especially when we're dealing with mental health. medication is sometimes important, or is always important for these individuals.
Okay. Thank you.
Commissioner Zick.
I wanted to follow up on what I understood to be a response that you made to a question from Commissioner Russell, and I may have misunderstood the conversation. I think she was trying to understand what the maximum number of people you would have at your facility, and I think in your response you were describing that you wanted to have a comfortable environment, and this is the part I may have wrong, that you anticipated 10 or 15 people maximum. Did I understand that right? And the reason why I'm asking you the question, so that I'm not trapping you accidentally, is you indicate on your letter, which is handwritten page 9, that you'll have no more than 35 people at the facility. So I guess I'm asking kind of again, what you expect to be the maximum number of people at your facility?
Sure. I'll be honest, my expectation is not to have 35 individual people there at one time. It's a little bit much for the space that we have. But if for us, as far as clients, I was referring to more between like 10, 15 at a time. As far as including staff, add them to that number. I had mentioned, if the capacity is at 35 total, I mean, throughout the day, if we were to eventually add another time frame, which we talked about earlier, I'm sure we'd have 35 clients throughout the day, but there never will be at once, even including staff. It would be nice if we expanded or something like that maybe, but not right now. That's not in my foresight.
Okay, and then I have a question for the landlord's representative. When you last spoke, you were talking about what I'd understood you to say was there exists some kind of a parking agreement between you and the other businesses located to the south of you. Did I understand you
Correct,
correct?
yes.
And that parking agreement, let me sort of ask it this way. If you have adequate parking at your building, you really wouldn't need to have any of your patrons park anywhere else. So I'm trying to understand the benefit or the reason for there being that parking agreement. Could you maybe give me the history of that?
I can only say what it says. It was written in 1965. I wasn't involved at that time. I'm just with the current landlord, but the goal of the agreement was to create the illusion of one shopping center from our parcel to 5 neighbors, I think, 5 addresses. So we're not allowed to stripe spaces exclusively for any particular tenant, and the cars are supposed to be able to, the tenants, customers are supposed to be able to run through the parking center and park wherever they want. So I don't sit there towing my neighbor's employees or my neighbor's tenants and vice versa. And if there were a problem, it would be from people that are not patrons of the center parking there, which I do have to honestly deal with, but it's not actually relevant to their use. It's might be somebody from the apartments across the street that wants to park because their parking's overflowing.
Okay, so with that understanding, Justin, in your presentation, I recall you saying something about the requirement that vehicles be able to move between the parcels. And I forgot how it was you described that condition is codified.
Yeah, and I was referencing the private agreement between the property owners that was recorded. It is an access agreement between the properties that ensures that between those properties there would be access and parking.
Okay, so the access agreement is what is recorded.
Mm-hmm.
Okay, what about the shared parking that he's describing?
So the agreement references parking, but it's not a city-recognized shared parking agreement.
Okay, for it to be a city-recognized shared parking agreement, what would have to happen?
Zoning code requires approval of a conditional use permit to allow off-site parking. in this case, which would be shared parking.
Okay. All right. And while I guess I have the mic, if I could ask staff another question, because I'm trying to understand this, again, this shortfall of parking at the parcel. So 88 spaces are required. There's only going to be 65 once it's restriped. So that's the shortfall of 23 spaces. This particular use of 3,082 square feet, recognizing that there are different uses in the building, but that represents only 14% of the total building. Yet their requirement is 31 spaces relative to a total of 88. And because there's the shortfall of spaces, that's what's driving the need for the minor conditional use permit. So my question is this: if they were already in operation and what was before us was one of these other tenants, they'd moved out and a new tenant was going to come in and do some similar business, tax preparation, the massage, whatever it is, would they then also require a minor conditional use permit? In other words, does every tenant in the building require a minor conditional use permit because each one shares in the overall burden of an underparked building?
No, because this is a legal non-conforming site, any use that is permitted in the C1 zone would be permitted.
Okay, so then explain to me why this use isn't?
It requires parking at a ratio of 10 spaces per 1,000 square feet instead of the 4 spaces per 1,000.
Gotcha. Okay, thank you.
Anyone else? Okay. Thank you, sir. We'll close the public hearing, I believe.
I just wanted to
Mr.
circle
Arias.
back to the approval for discretionary approvals on the site. Looking through the tenant list, the only one is for the dance studio. There are, I believe, an approval for a wireless on the top of the building, and then there is one MCP that is also in process.
For the dance studio?
It's for a separate yoga studio.
Okay, close the public hearing. Commissioners, comments, motions? I should go back to my screen to see if there are any. And there is a motion by Commissioner Perkins, with a second by Harlan. And that, to go ahead and communicate your motion, Mr. Commissioner Perkins, and then we'll.
And then make comments afterwards?
Yes, sir.
Got it. So I find that the project is categorically exempt from the provisions of the California Environmental Quality Act per CEQA Guidelines Section 15301, existing facilities, and further move that we approve zoning application 19-83, subject to conditions of approval, with a modification that I would like to make to condition of approval number 2, the programming hours of operation, to help facilitate business growth and lack of people having to come back every time something changes. I would like to propose the programming hours of operation be Monday through Friday, 9 a.m. to 4 p.m. to give them room for growth.
Okay, there's a motion, Commissioner Harlan, or Vice Chair Harlan.
I'm sorry, can you repeat that? It's Monday through Friday, 9 a.m. to 4 p.m.?
9 a.m. through 4 p.m., so half an hour after their staff get there to half an hour before their staff close.
Sure, I would agree to that.
Okay, there's a motion and a second. Any comments? Commissioner Perkins.
Yeah, I just wanted to mention in this that I think parking is obviously a challenging issue that we need to look at as a city, but speaking generally, parking minimums can have the effect of stifling the creation of a financially or economically viable city and a thriving community. And in general, again, if we have facilities, actually of which like this was an example where you have shared parking with differing uses and differing hours. So like say Coco's, you're gonna have a lot of people parking at night, not during the day. Overlapping parking requirements can dramatically reduce the amount of parking we need while still letting everybody park. This is a location I travel by regularly. I work at Orange Coast College and live nearby. I don't know that I've ever seen that parking lot, the combined whole lot there, ever full. And so I am pleased to support this motion.
Okay. Vice Chair Harlan, and then I have a comment.
Thank you, Mr. Chair. I have a little different take than my colleague, although I agree with his comments. I mean, to my mind, the use is okay. It's allowed within a C1 zone, and the prior use of the tenant space seemed to be exactly what's being presented here. So really the question is the parking deviation merited? And to my mind, there certainly is capacity here at the site. And it seems like what the applicant is proposing is far below, as far as having 4 parking spaces, far below what is really often needed in this type of situation. And further, it seems like the landlord is okay with this use and the parking. I have a hard time believing a property owner would want to do something adverse to his interests. Why would you have a use there that is going to adversely impact other tenants? So for those reasons, I'll support the motion.
Okay, and I will also support the motion. For 90% of what Vice Chair Harlan said, it's permitted in the code, in the C, in the commercial zone. It is a use that has been there before. And I will add just that it goes to show again that I think our parking standards are outdated and outmoded. And I know we will be taking a look at them. And I've lived in Costa Mesa since 1993, and I know that center very well because I've spent tens of thousands of dollars in that Cocos, I think, when my kids were growing up. That parking lot isn't ever been close to full, ever, that I've ever seen, and maybe not even 75% full. There's also the very real possibility that a large retailer there may close at some point in the near future, given the recent announcements by Pier 1. So I don't see this use at all being even remotely being a drag or a huge demand on the parking capacity there. So I will support the motion. Yes.
Well, I wasn't going to comment, but I'll support the motion. I'll also say that I have a long history with the businesses at this location. It's near where I live, and I've been there 40 years. I've seen that parking lot full. It isn't full now. Businesses are struggling now. If it was a vibrant business center, parking would absolutely be a problem. I agree that some of our parking codes need to be reviewed, but if I go to a business and have a hard time parking, I don't care what you think about the parking code. The result of it is insufficient parking. But I'm supporting your motion. Thank you, Mr. Chairman.
Okay, anyone else? Commissioner Colbert.
Thank you, Chair. My question, this was pretty difficult for me, but it goes back to my initial question related to the use. I'm glad that this got kicked up to the commission. However, I think this is something that we, in the code cycle cleanup should particularly look at uses like this and more common uses that are becoming more prevalent that we have to deal with on these bases, specifically related to parking requirements. I'm particularly interested in this because I feel like there's a super gray area between what constitutes as a medical use and what constitutes as a trade or vocational school. I would never classify this as trade or vocational, but this is, so that's just particularly interesting to me. Additionally, as it relates to the justifications of approval, like Commissioner Zick just stated, when this area is full, I believe that the impact will be materially detrimental to other properties within the area, or could be potentially materially detrimental to the properties in the area. So I just want us to really think about what's justifications for approval that we use to support particular recommendations to the commission, and really think about these medical uses or vocational uses as they become more common and due to their programming and operational types, could become potential impact to other retail uses just based off of the services that they offer. Thank you.
Okay, and I'll call for the question.
That motion carries 7-0.
Okay, and that decision is final unless appealed to the city council within 7 days. Thank you. One more. Yeah, okay. Okay, Julie, next item, please. Public hearing 3.
Public hearing item number 3, zoning application 19-91, amending minor conditional use permit ZA-15-30 for an existing restaurant, the Halal Guys, regarding condition of approval number 4, requiring on-site security for the business at 3033 Bristol Street, Suite E. This is a call to report. Any ex parte communications?
Commissioners, any communications to report? Okay, seeing none, Mr. Lee.
Yes, Happy New Year, Mr. Chair and Commissioners. I'm Mel Lee, I'm Senior Planner. This application is zoning application ZA 1991, which is actually amending an earlier zoning application 15-30. The request is specifically to amend the original minor conditional use permit for the Halal Guys restaurant, specifically to remove a condition of approval that requires the applicant to provide a security guard during certain hours and days of the week. The applicant is requesting that this condition of approval be deleted due to a lack of security-related problems with the business. By way of background, the subject property is located in the 3033 Center, cat-a-corner to Bristol Street and Paularino Avenue. It's an existing one-story retail center, approximately 39,000 square feet in size, give or take. And the Halal Guys restaurant occupies 1,400 square foot space within this shopping center. As you can see in the zoning district map here, the zoning is C1, which is local business district, and with the exception of the apartments immediately abutting the site to the west, the surrounding properties are zoned commercial and contain commercial uses. So this is a site plan exhibit that shows the tenant spaces within the center with the Halal Guys restaurant shaded at the bottom of the slide. And this floor plan layout basically shows the dining area relative to the main entrance towards the front of the building, the rest being the food preparation, restrooms, and food storage areas. It should be pointed out that because this particular amendment is to a condition of approval, there are no changes to either the floor plan layout or location. Here are some photographs of the existing site. Actually, the Halal Guys, Capital Noodle Bar, and the other restaurant that's in the center of this slide, one point in time was all originally Orchid Restaurant. Orchid Restaurant closed, I believe, in 2014, and basically the Halal Guys and the two other restaurants basically occupied the former Orchid Restaurant space. So the original request, the zoning application 15-30, was a minor conditional use permit to allow the restaurant to be open until 3 a.m., 7 days a week. Because the property abuts residentially zoned properties, this would have necessitated a minor conditional use permit. However, this application was actually denied by the zoning administrator on September 11th, 2015, partly because of the number of correspondence the zoning administrator received in regards to public notice. There was 11 written comments that were submitted in opposition to the request, citing potential for noise, trash, and overflow traffic and parking impacts within the adjacent residential neighborhoods. So after the zoning administrator denied the request, the applicant appealed the zoning administrator's denial to the Planning Commission at their October 26, 2015 meeting. They considered the request. However, in the appeal, the applicant amended the request. Instead of closing at 3 a.m., which was the original request, they had changed it to close at 12 a.m. Sunday through Wednesday and 1 a.m. Thursday through Saturday, and also proposed providing an on-site security guard from 11 p.m. to 1:30 a.m. The Planning Commission did vote to continue the item to the December 14th, 2015 meeting, and requested that the item be re-noticed for that meeting to provide the applicant with an opportunity to address neighbor concerns. So at the December 14th, 2015 meeting, the applicant took some additional measures to address the community concerns, including agreeing to provide on-site security, which was reflected in condition of approval number 4. And so the Planning Commission did vote to approve the request as revised. The commission also requested that staff bring the item back for a 3-month review, which they received and filed in April of the following year, after it was confirmed that no additional complaints had been received during that 3-month period. So this is the current wording of condition of approval number 4, which basically requires a uniformed security officer be physically stationed on the site in the evening hours and specifying the days of the week. The security officer is required to patrol the property. Loitering and noise disturbances have to be appropriately managed by the security officer. And the security officer would also ensure that any businesses operating past 11 p.m. do not have amplified noise streaming from their places of business. As I mentioned, the applicant is proposing to remove this condition based upon the fact that since the original conditions of approval were put in place, there have been a lack of security-related problems with the business. After reviewing the applicant's request, staff is recommending that rather than remove the condition of approval as requested by the applicant, staff recommends that condition of approval number 4 be amended to authorize the Development Services Director to temporarily suspend the requirement to comply with condition of approval number 4, and until such time as the director determines that compliance should once again be required. So in other words, if the condition of approval is suspended, this would basically give the director the ability to reinstate compliance with the requirements. And it should be noted that this responsibility would fall upon the property owner should the director decide that reimplementation of condition of approval number 4 is warranted. Also, the property owner who is ultimately responsible for ensuring the use is compatible with the surrounding neighborhood would be given written notice of such a determination and would have the ability to appeal that determination to the Planning Commission if needed. It should also be pointed out that we did review the requests with the city's police department, and they have no concerns with suspending the requirements as specified in condition of approval number 4. And also they had followed up their comments with a supplemental memo that was attached to your packets this evening. So staff recommends that the Planning Commission take the following actions. Find that the project is categorically exempt from the provisions of the California Environmental Quality Act, CEQA, per CEQA guidelines section 15301 for existing facilities, and also authorize the Development Service Director to, at his or her discretion, temporarily suspend the requirement to comply with condition of approval number 4. The Development Services Director may, at his or her discretion, reinstate this requirement based upon evidence of adverse impacts. This concludes my presentation. I can respond to any questions the commissioners may have.
Thank you, Mr. Lee, very much. I will look down the line and see if there's any questions. We've got Commissioner Perkins, Commissioner Colbert, Commissioner Zick. Okay, so we'll start with Commissioner Perkins.
All right, thank you. One question I had, and this relates to the police department memo that we have on page number 3. It says, as of 2016, the Costa Mesa Police Department has responded to et cetera, incidents. Should that be since 2016? It seems...
Yes, that's correct.
Okay. And then I'm also curious, the condition of approval for a small restaurant to have a security guard seems a little bit odd to me. Have other businesses in the area that are open late, and I know you've got Subway, you've got Hashigo, I think Anjin, and like 7-Eleven are all open past 11 p.m. Do other businesses in the area have similar conditions of approval attached to them, or is this a common thing in the city of Costa Mesa?
It would be a condition of approval if the police department recommends it be the case. In this particular instance, however, it was the applicant who proposed the security guard requirement based on the ZA's denial and the concerns the Planning Commission had raised during the public hearing regarding they had received all the correspondence that were citing all of the issues with them being open late hours, so they wanted to give them a trial period of operation to see if appropriate security measures were warranted. And after the review in December, they decided to make that a permanent requirement per the conditions of approval.
Okay. And thank you for that. Is this similar condition of approval on other adjacent businesses that are open late, and is it commonly applied to restaurants that are open, say, after 11 p.m.? I guess in my late night travels to restaurants, I don't typically see security guards hanging around outside in the city. So I'm just wondering if I'm just not seeing them, or if, is it common?
You are correct. This is not a common condition of approval that's applied to restaurants. Typically, the police department will recommend it for nightclubs, sometimes bars, but rarely for restaurants.
Okay. And the other thing I was wondering about is, I know it was referred to in here that there was a phone number given to residents to issue questions or complaints on. Is that something that we have data on? Would the applicant have data on how many complaints that number received?
Yes, the applicant has that information.
Thank you. And that is all my questions.
Okay, Commissioner Colbert?
I think 2 of my questions were answered at the top, but I have one last remaining question related to the security company, and maybe the applicant or the staff could answer. Is this the same company that has been there since 2015 when it was the condition? This is the same security company?
I believe that's the case, yes.
Okay, thank you.
Okay, Commissioner Zick.
Thank you, Mr. Chairman. So I recognize from your explanation that the security guard exists because the halal guy suggested it, and it was ultimately agreed to. Since it was part of a MCUP, does that mean that the property owner of the multi-tenant businesses is the one who is ultimately accountable for complying with all the conditions of approval as opposed to just halal guys?
That is correct.
Okay. And so with your comment that with this proposed suspension of the requirement and the potential of it being reinstated, that in reinstating it, you have said something that didn't feel like then it needed to be said, and that was that the onus would fall on the owner. Didn't the onus fall on the owner by definition anyway?
That is correct. However, in this instance, and the applicant can explain this further, the actual restaurant operator is the one that is basically paying for the security service at this point.
So with the way you've described it as the owner being accountable in the future, should this be reinstated, does the owner know that?
Yes, as having the halal guys be his authorized agent, basically he is acting on behalf of the property owner. And the property owner it would be aware of it because he not only is he copied on the notice, he's also copied on the staff report and the resolutions as well as staff's recommendation.
Okay, thank you. And I think it's a very creative solution, and good job on that.
Okay. I will open the public hearing, ask the applicant to come forward. If you have any presentation you'd like to make or any comments.
Hello, I'm
Yes, sir.
Elisa Perry. I'm one of the owners of the Halal Guys. I'd just like to thank you all for your time, first of all. Secondly, I'd like to address that when we first opened the restaurant, we had a large number of customers coming to us. They were excited about our brand, first to market. And as a result, there was a lot of trash. There was the yellow bags in the street, and that was also one of the reasons we got so many complaints from the neighborhoods. As a result, we implemented that a procedure that all of our staff be aware of that and pick up the trash as they enter and leave the plaza and the neighborhoods as well. As far as parking, we have valet parking available to take care of that issue. And the security, as mentioned before, we haven't had many or any issues at all involving the police department, so we feel that the security requirement is not necessary.
Okay, thank you. And you've read the staff report and agree with the conditions of approval?
Yes.
Great, okay. Commissioners, any questions of the applicant?
Yes, Mr. Chair.
Commissioner Zick.
You mentioned you have valet parking. Why is that necessary?
Because during lunch hours especially, there's a lot of traffic in and out. It's hard to find parking, so as a result, they're able to pull up to a valet and hop out of their car, and then the valet will find the parking for them.
Must be a successful shopping center.
It's a very busy center right now, yes.
Yeah, thank you very much.
Thank you.
Okay, Commissioner Perkins.
Yeah, just wanted to follow up on the question on the phone number that was given to residents. Do you have the data or information on how many called?
Yes, so I checked with the property manager and the general manager for our restaurant who received no complaints at all.
Thank you.
Thank you.
That's it.
Okay, anybody else? Okay, thank you, sir. We'll open public comment. I don't think we're going to have any because the place is empty. I will close public comment, and also, unless there's any other questions, close the public hearing. Thank you, gentlemen. You can have a seat.
Thank you.
Any final questions of staff? Okay, I'm going to make a motion, find that the project is categorically exempt from the provisions of the California Environmental Quality Act per CEQA Guidelines Section 15301 existing facilities. Authorize the Development Services Director to, in his or her discretion, temporarily suspend the requirement to comply with condition of approval number 4 of zoning application 15-30. The Development Services Director may, in his or her discretion, reinstate this requirement based on evidence of adverse impacts as discussed in the staff report. And is there a second? There is, by Commissioner Zick. Final comments. Commissioner Russell.
Yeah, I feel really comfortable having this be something that can be reinstated. When I walked around the perimeter of the property, it was extraordinarily clean, down the alleyway and stuff. And I'm wondering if the reason that it's so clean is because they have the guard. And I just want to compliment you guys because you're doing a really good job of keeping it clean. I went down there Saturday night, and the valet seemed to be working. Anyway, I'm very much in support of the motion.
Okay, Commissioner Torje, and then Commissioner Perkins.
Yeah, I'm also in support of the motion. I'm really familiar with Halal Guys as I frequent that shopping center often. And I do have to say that the security measures seem, while they made sense, I think, in the beginning, seem extreme now. And so I'm very much in support of the motion.
Okay, Commissioner Perkins.
Yeah, same thing. I also took the opportunity as an excuse for a midnight run to Halal Guys on Saturday night, and was also very impressed with the surrounding residential area and the shopping center itself. So again, excellent work on that. And I know the constraint on the initial operating hours was potentially due to concerns over that. So it's obviously not what we're talking about tonight, but I wonder if it would be interesting to entertain at a future date a revision of those hours, because late night operations are important for the viability of a city and community as we get a younger audience, and especially as we have things like Education First moving in less than a mile away, where we're going to have 600 students on site. So it's interesting to think about what those students are going to need. So again, excellent work. Thank you very much. And I will support the motion.
Okay, and I will call for the question.
That motion carried 7-0.
Okay, and that decision is final unless appealed to the city council within 7 days. Continued good luck, gentlemen. Okay, and that brings us to departmental reports. Are there any public service report tonight?
Not tonight, thanks.
Okay. Mr. Curtis, Development Services.
None this evening, Mr. Chairman.
Okay, Mr. Preziosi, City Attorney.
No report, Chair.
Okay. What I would like to do tonight is adjourn tonight's meeting in honor of Rob Hammers, who unfortunately passed away suddenly just this last week. Rob was a longtime engineer with Costa Mesa Sanitary District. Had been with the district since 1982, actually served as district manager from 1992 to 2009. And so we want to thank him for his service to the community, and may he rest in peace. And we will adjourn the meeting in his honor and his memory to our regular scheduled meeting of January 27th. Good night.